So just again, a super warm welcome to everyone. Really looking forward to our time ahead. And I'm just going to pass the time across to Samantha, who's our vice chair, to also say her hellos to you.
Hi, everyone. Welcome to join our first Young AIPPI Members Summit. And we are so glad to see all of you here. And I know some of you are joining in the early morning. Some of us are in the afternoon. But wherever you are, a huge warm welcome from us, from the Young Members Committee. So today, I'm so thankful and so happy that we have a lot of our young members joining and also will be speaking with us today. So hope you guys have a great time. And now I'm going to pass the time to our General Secretary General, Ms. Annie Tsoi, to say a few words. Thank you.
Thank you. Welcome, good morning and good afternoon. Welcome to the inaugural Young AIPPI Members Summit. Since the Congress in Sydney 2017, we have been hosting a Young AIPPI Members Forum every year during our annual Congress. This is a special forum specifically designed for our young members to gather together to learn new skills and to build their network within the AIPPI community. This year, we are launching a new event organized by our young members for the young members. And I would like to give a big thank you to our YAC, the Young AIPPI Young Members Committees, especially Debbie and Samantha, the chair and the vice chair of our YAC, for all their hard work for making this summit possible. In the next few hours, I hope that you will be able to benefit from the sharing of other young members on issues such as the Metaverse, SEPs, life sciences. There will also be sessions on leadership skills. Most importantly, of course, is to meet new friends. So stay for the AIPPI cafes where you will have a chance to discuss some of the hot topics with colleagues around the world. Thank you for joining us today. And before we start the program, I believe that Debbie and Samantha will have some housekeeping points they would like to mention. Over back to you, Samantha and Debbie.
Thanks so much, Annie. And we're so excited. And so before we start today's program, there's a few points that we want to take your attention to. So this event will be recorded and made available on demand for about 1 month time. So if you want to go back to review it, there will be a link available. And so during this presentation, we also invite you all to please mute yourself when you're not speaking. And please feel free to submit any questions you have during this summit in the chat box so that they could be addressed during the Q&A session. If you have any technical problems or difficulties, do send a message to us at the chat box to AIPPI events. We have a great team here to help us, and we just really want to a big shout out to all their support from the AIPPI events team. So if you want to revisit some of the slides that are used today, they can be made available upon request. So do write to events@aippi.org if you would like to request for a copy. So without further ado, I know you guys are excited. We are going to start our program today. So over back to you, Debbie, and thanks a lot.
Thank you, Samantha, and thank you, Annie, as well for your opening remarks. And welcome again, everyone. For those of you that have just jumped in and joined us, we are gonna head straight into session 1. And I think just before we start, I just want all of you to know that you should just feel completely relaxed and comfortable. Grab a coffee, grab a tea, just enjoy yourself, and just feel comfortable in this environment as we have the couple of hours ahead together. I don't want you to feel like this is a huge, big official program that's scary, but it's just, friends sitting around, enjoying each other's company and enjoying the sharing that we have before us. So let's go right into session 1. And session 1 is titled Exploring a Brand New World in the Metaverse and Related IP Issues. And we have 3 lovely ladies on our panel today for this session. And I'm just going to provide a quick introduction for all 3 of them. And before inviting Samantha to get us started. And so I'll introduce Samantha. Samantha Young is a senior associate at Deacons Hong Kong, and she is part of the China Intellectual Property Practice Group. Her practice covers IP protection and enforcement, but also extends to China-related data privacy and cybersecurity issues. She has been particularly active in the area of cutting-edge IP and IT issues related to cryptocurrencies, NFTs, and the Metaverse. Samantha joined AIPPI in 2017, and as you know, she is the Vice Chairperson of the Young AIPPI Members Advisory Committee. Secondly, we have Serena Totino, who is Senior Associate at K&L Gates LLP, London. She is a member of the IP Practice Group. She deals with trademarks, designs, and copyright matters for international companies with a focus on the fashion and luxury industries. She's also qualified in Italy and has also practiced in the US and Denmark before moving to the UK. Hello, Serena. Finally, we have İrem Bezek, an associate with Darius in Turkey. She is an intellectual property lawyer representing local and international clients in trademarks, patents, designs, copyright, and unfair competition disputes before Turkish courts. She's involved in conducting anti-counterfeiting projects, including protection of IP rights before the customs. İrem also advises clients in trademark prosecution, opposition, and domain name matters. Hello there, İrem, to you. So we have these three wonderful speakers to get us started on our journey today. And so I'll just invite Samantha, who's going to be speaking first, to take the floor.
Thanks a lot, Debbie. So as Debbie mentioned, today our topic is exploring a brand new world in the metaverse and related IP issues. So I'm sure a lot of you are now very familiar with this term metaverse. And why is this such a hype, or is this the future for all of us? So basically, this term actually first came about in a novel called The Snow Crash, which features a computer-generated universe. This concept is still developing, although there is no universal definition. But from a lot of different definitions and our experience now, it mainly revolves with a 3D online virtual world that facilitates experiential and real-time interactions where people can interact with each other in the form of an avatar, and also interact and do different activities and games in the virtual world. So why is the metaverse such a huge topic now? It is estimated that this metaverse space has a potential reaching $1 trillion USD market cap. And as we see in this graph, that actually there are a few main sectors that are very developing and has huge potential. One of it is the advertising sector, which, you know, when the metaverse is created and people get into virtual worlds, there are so many more spaces for people to advertise, to showcase their campaigns, to interact with different people all around the world. And we can imagine the capacity and the potential in this space is huge. And there will also be a lot of IP related issues for us to consider. In that connection, there is also the social commerce industry, which will also boom. As we know that e-commerce platforms and e-commerce space is booming. Just imagine being able to participate in a virtual world, shopping with your friends, and also meeting the influencers in the virtual world together and seeing the products online. In a very interactive way. So we can imagine that this space is going to bloom. In addition, with the COVID situation now, digital events are now very popular. And so we can see like Ariana Grande's concert on Fortnite, which helped the singer just earn millions of dollars. We will be seeing a lot more events and young people joining in events in the metaverse. So before we turn into discussing some of the IP issues, there's actually a lot of different terminologies that we will be discussing. First of all, like Web 2 and versus Web 3. In the Web 2 generation of internet services, when the technology allows people to share a lot of information, such as the share economy and user-generated content, in this era of internet services, it covers still by a lot of platform-centric centralized companies, such as Twitter, Amazon, Alibaba, Uber, etc. But when the technology now now we go into the third generation of internet services in the Web3 with the technology of AI and 3D imaging and the use of blockchain technology. A lot of services can now be transformed into more decentralized process and eliminating the middleman, as well as also the metaverse being able to be built on the blockchain technology. And therefore, there are a lot more utilization. Also, maybe with the metaverse, you will hear a lot of the term DAO, DAO, which is the decentralized autonomous organization. And what this means is that it is also a self-organizing, mission-based community of people where maybe a lot of people haven't met each other at all, but they come together to build a project and make decisions together, such as it's just like a government where people can vote and make decisions of the project together. And they're like a government which determines the future of the projects, such as some of the NFT projects or even the metaverse space. The next is decentralized finance, the DeFi. It's actually a computer program that acts on lending and borrowing, automatically removing the middleman. And so people can buy cryptocurrencies. They connect to exchanges to sell their cryptocurrencies back into stable coins and then back to their fiat currency. So this really eliminates the middleman. And the next term is GameFi, which is gaming with decentralized finance. It is like a combination of the term of gaming and decentralized finance. It describes the integration of blockchain application in the gaming sector for monetization, and people can actually play while they earn in the games. And also NFTs is actually also a very hot topic and widely discussed, especially with in our IP sector. It is the non-fungible tokens, which is a unique digital identifier that cannot be copied, substituted, or subdivided, and is recorded in a smart contract in a blockchain, so that this can certify the authenticity and ownership of the digital assets that one owns. And this facilitates also with the transactions in the metaverse. So moving on, we'll look into different types of metaverse, because we hear a lot of different metaverses, but what are the differences and how do they operate? With the metaverse, we hear about Roblox last year being listed in the New York Stock Exchange just last year, and Fortnite, also a very popular game. So what they do is they allow players in the game to build to build their world together, build their games. But this is essentially owned type of metaverse. It is owned by the companies, and they store all their data and also the digital assets in one place in this in their own storage. And the digital assets are actually non-transferable. You can't sell it out of that space. This type of metaverse is more centralized in a sense. Whereas there's also some type of metaverse in the social media, such as last year, we heard that Facebook is changing their name to Meta, and they are creating their own metaverse, Horizon Worlds. And with their Horizon Worlds, it's also creating a socializing space for people to work and play in virtual reality. But mainly it is supported with the AR, VR headsets that are created by Meta, which is the Oculus system. Oculus lens, and also with Baidu in China, they're also developing their rather closed type of metaverse platform where they allow users to go into the world with any types of devices, but you can explore their first city called Xirang, which is also the term for the land of hope. They have hosted their first Baidu AI Developers Conference in the end of last year in this new space. So I think this type of metaverse spaces, which are also owned by a more closed Web 2 type of metaverse, are also developing. The next type of metaverse that we see and are very popular is the Web3 type of blockchain metaverse. Some of the popular examples are Decentraland and Sandbox. They use the blockchain technology, which also then creates their own digital assets that can be transferred, that can be sold and in secondary markets, and in the ownership of NFTs. So they have types of NFTs, including their land. The land is sold in parcels in the form of NFTs. So it is a limited supply, and so that's why it creates also a supply and demand economy, limiting the supply of the land. And this can be bought through their own cryptocurrency token that is used within their metaverse platform, or it can be bought by other cryptocurrencies such as Ethereum. And then within this metaverse platform, they are governed by DAOs, and the decisions are made by the people who have stakes in these metaverse, such as if you own a piece of land or if you earn certain amount of the tokens within the metaverse, you will be able to vote and have a say within this world. So it's kind of like a new world that is created with their own economy, and also their own governing system. So in these type of metaverses, people play to earn, and also you use your avatar as your identity, but it can also be interoperable. So you can also use the same identity in different types of these metaverses. And as mentioned, you can use a cryptocurrency that can be changed into local money in these platforms. So what are people doing in these metaverse platforms? So a lot of brand owners are entering into these metaverses and also promoting their products. As you see with Heineken, they have established their shop and also rolled out their first virtual product, which is the first virtual beer, as you can see. And what is interesting with Heineken is that they have used this as their marketing campaign. At the same time, we also noticed that they have filed a design application for this virtual beer can design, but as a physical good, as a beer can itself, and not a virtual beer can. So we can see that IP owners are actually protecting their IPs in the metaverse, as well as also concerned whether any virtual products in the metaverse would be copied or infringed in the real world. So we can see that there are a protection both online and offline now, with different types of applications, including designs, trademark, which we'll be talking in a bit. With Samsung, you can also see that they have actually recreated their headquarters, their New York flagship shop in Decentraland as well. And with when you enter into their flagship store, you can also do a lot of interactive games, and you can also find out about their latest products. They have also different activities that you can do to earn some limited edition digital collectibles, which increases engagement with users, and is also a great opportunity for them to market and to showcase their new products. Also, Gucci on Roblox has created their new their Gucci garden. They also showcase and create an environment that matches their Gucci campaign. And there's also a place where people inside Roblox, the users, can buy virtual Gucci bags and different products, and it's a great way for owners to promote and reach out to the new generation of users. With Fortnite, you can see that brand owners also license their IP with the metaverse platforms. Fortnite allows users to use different characters as their avatars. So in this case, you can see that Marvel has licensed and worked with Fortnite so that users can also take form their avatars as Iron Man, and also all different Marvel characters. So so as you can see, IP licensing in the metaverse space will be very big and popular, and with all this happening, we should also warn and be aware to advise our clients that to set clear arrangements with metaverse platforms, also clearly set out the term and also the territory, because it can be confusing with everything being online. And the royalty and the commercialization rights, etc. But they're giving them the right to use in a certain area, allows them to actually commercialize in other situations as well, and that has to be very clearly defined. Also limiting the scope of use of the IPs, and it's also important for clients to review the metaverse platform's terms and conditions, if there's any restrictions in terms of them using their brands, their logos and trademarks in the metaverse, and also any end user licenses. It's also important to see if that specific metaverse platform has any complaint mechanisms in terms of third-party IP infringements, and also for the IP issuance and purchase, it's also important to review and to make clear that there are the terms and conditions which will govern the IP rights, because just the mere purchase of the NFT does not mean that the buyer or the purchaser will get all of the IP rights behind that artwork or that specific music, etc. Because as later Serena will also touch upon, it is very important to set out the terms of how the IP behind the NFTs should be allocated, whether it is issued as a license or how the royalties to the author, the creator, should be aligned as well. So now I'll quickly also talk a little bit about the metaverse strategy in China. So actually, with a metaverse being very popular, China's big tech companies are also exploring and investing in this space. As I've mentioned, Baidu is creating their own metaverse, and also Alibaba is investing in their cloud metaverse solutions, etc. And by end of last year and beginning of this year, there are actually a lot of companies trying to file trademarks that feature the word metaverse in Chinese or in English as well. But we have also recently noticed that the CNIPA is refusing a lot of these applications, mainly on the absolute grounds that they're actually metaverse, this term is very specific and unique, and it is not for everyone to monopolize on this term, and not all of the classes of goods and services actually are covered by this term metaverse, and it might create and mislead the public. So that's why some of the registrations which has been approved have also been rejected and invalidated afterwards. So we see that this has been an issue. In terms of trademark protection in China, because it adopts the WIPO classification, and there's actually no current standard items for virtual goods or virtual services that are applicable with metaverse. Some of our clients have inquired, actually many clients actually are very interested now in the metaverse space and ask us if they can help, if we can help with filing trademarks to cover more protection in the metaverse. So now basically, we would suggest to apply for some of the standard items that are related to the virtual reality or virtual goods related, but in this stage, we anticipate that the CNIP will likely amend the classifications, maybe to adopt for more flexibility for some of the virtual goods and virtual services type categories. So lastly, just want to talk about a little bit about the protection of everyone being in the metaverse space. We will be in the form of an avatar, although it represents us, it represents who we are, we interact with other people, but because it is not a person per se, they will not have name rights or image rights. But mainly with 3D virtual characters, it will be mainly protected by copyright, trademark, and anti-unfair competition law in China. And so this can be illustrated in a case where in Shanghai MiHoYo and Guangzhou Yixu case, where MiHoYo, the plaintiff, created this 3D character, which is an avatar, and the defendant has used it without the authorization. And the issue then goes to whether and MiHoYo does have this right against the defendant. And because MiHoYo has filed a copyright recordal as a prima facie evidence, and also because they have used it even very briefly and can support it with evidence of use, then the defendant is liable to discretionary compensation to the plaintiff based on copyright infringement. So I think lastly, I just want to point a little bit about the recent development of the China's metaverse strategy. Although China is also very vigilant in allowing the different developments of a metaverse and cryptocurrency, but at the same time, they notice that it is a huge space with a lot of potential. So in the People's Congress in March, there are proposals to request for the strengthening of supervision of metaverse development and to also formulate some regulatory laws to govern the space a little more. And also with the affiliation of the PRC Ministry of Industry and Information Technology, the MIIT, there's an established association which is under the China Mobile Communications Association of Metaverse Consensus Circle, which actually is responsible for promoting the metaverse industry, but also promoting that all the people, the players in the industry, to self-regulate themselves, to avoid any speculation, to guide reasonable expectations, to establish clear responsibilities and liabilities, to curb illegal financial activities, or to mislead people into metaverse investment projects or virtual currencies, etc. So overall, we anticipate that there will be more laws and regulations and directives to be issued governing the metaverse space and industry in China. So now I'll thank you so much for listening to my part, and I will pass on to Serena to talk a little bit more about metaverse and IP enforcement. Thank you.
Hi, everyone. What a great introduction, Samantha. Let's now take a helicopter view and speak about the IP enforcement in the metaverse. First of all, how do you acquire IP rights in the metaverse? Let's get started and look at trademarks. So as Samantha mentioned before, trademarks will still serve the same purpose in the metaverse. So they will still function as an indication of the source of the goods and services. However, there are some specific issues that we are looking at this moment in time. And the first one is, are tangible goods the same as virtual goods? Well, on one hand, you might think that it might actually be the same type of goods, just sold in a different environment. However, if we use the similarity test that we have been using so far, we may actually notice that virtual goods might be closer to a software type of good rather than the normal tangible goods that we are used to. So the community is now divided into, understanding what's the nature of the goods used in the metaverse. So this brings us to the first problem, which is, are current registrations sufficient to cover use of the trademarks in the metaverse? We will look at this a bit more in detail with a case law review later on, but the answer might be yes, especially because it's still quite a young space. However, it is recommended to integrate your trademark portfolio with new registrations, for example, covering goods used in the virtual world and listing, for example, classes 9, 42, and so on, depending on the nature of the business. The second issue is about territoriality. As we mentioned before, the element of territory might not be seen and assessed the same way in the metaverse. So the first question is, can we still use targeting elements to understand in which territory the trademark is being used? Well, the answer might actually be no, because it is quite difficult to use the same elements in the metaverse, especially because the metaverse is a decentralized type of environment where we are not looking at things like, the language used on a website, or whether the goods can be shipped in a certain territory, or whether, for example, a certain currency is available, especially because, as we've seen before, we are using cryptocurrencies, and goods might not be shipped at all because they might just be made for use in the metaverse. So these are the main points that we are seeing at the moment with trademarks. With regard to domain names, we are seeing at the moment an increase in bad faith registrations, especially because using a reference to cryptocurrencies, NFTs, or the metaverse might be a good way to actually obtain some visibility and pretend to be associated with well-known brands. We are also seeing initial registrations in the blockchain domain names, especially in the Ethereum space. So the advice here is to review the domain name portfolios to understand if an integration is needed, especially for blockchain domain names, and also review watch services that are in place at the moment. Because the number one problem with domain names is that the system to recover them at the moment is not as good as the one we're used to in the online world. So it might actually, a late registration might actually cause several issues to brands. Moving on to copyright, there are a number of issues that are quite relevant, especially when it comes to NFTs. So as we said, NFTs are certificate of ownerships, and these are functioned through the blockchain technology. And the number one thing to keep in mind is that if you're buying an NFT, you're not necessarily obtain copyright in that work. And especially the type of rights that are licensed or transferred to the NFT owner might actually not be as comprehensive as you might think. So it is important to make sure that the terms of sale are actually compliant with the intended use of the NFTs, and it is important to ensure that there is no conflict between the smart contract and the terms and conditions that are set out in the platform where you're buying the NFT. So there are a number of contractual issues that might come into play. So what are the issues in terms of enforcement, copyright enforcement in the metaverse? Well, the first one is that it might actually be difficult to identify the author of a work, as well as the identity of the infringers. So it is quite difficult to connect who's behind a certain transaction, even though that transaction appears quite clear on the blockchain. But it is quite likely that those type of transactions are happening anonymously. And it is also quite difficult to understand if a certain work is authentic and if the person creating that NFT is actually own all the rights to create that piece of work. So the number one issue here is that we do not have an authority to complain to on what happens on the blockchain. It is quite hard to, or probably impossible, to delete something on the blockchain. So what we have at the moment is systems of notice and takedown provided by the platforms, although these might not be as developed as the ones we are used to in the online world. And even if we want to use the normal judicial system, the issue might be how do we implement their court decisions in the blockchain. So that's also another issue. And also, copyright holders should be aware that there are a number of fair use defenses that potential infringers might be relying upon. So it is quite a complex type of environment. But let's see what brands can actually do in this decentralized space. Well, brands can adopt a more active or a defensive strategy. So they might be willing to test this environment with all the challenges that come with it and all the great opportunities from a commercial perspective, but might also wish to adopt a more defensive strategy and wait to see what happens in the near future. So either way, it is important to audit existing IP rights, so understanding what type of rights your brand owns, and to monitor use of IP in the metaverse. So it is important to be aware of infringing in the metaverse. And it is important for this, to this end, to expand on your clearance searches and also watch services to be aware of any type of infringement which is going on Web3. And of course, to eliminate some of the uncertainties, it might be useful to integrate your trademark portfolio with trademark and new trademark applications, as we've seen, which may cover different goods, especially in class 9 and 42, and also conduct contractual review. So it is important, as Samantha said before, to review your copyright license or your licenses more generally to make sure that they do cover or they do not cover metaverse use. So this is, of course, something that we advise both in terms of contracts that have been signed in the past and contracts that will be signed in the future. In terms of commercial opportunities, it is quite key and relevant commercial opportunity to consider partnership in the metaverse. And this might also be important from a trademark perspective, because if we obtain new registrations covering use of goods in the virtual world, it is important to make sure that we use that trademark in the metaverse to minimize the risk of invalidation actions at a later stage. And also, there are new opportunities for brands when it comes to counterfeitings and trying to use NFTs as a tool to tackle counterfeits. So let's now review a few case law that we do have and that may provide some guidelines in this uncertain world. Well, the first one is the quite famous Hermes case. So I think this is one of the first cases that we are aware of. And in this case, Hermes sued Maison Rothschild, which is a US artist who created and sold some Birkin bags inspired NFTs. And Hermes sued this artist, arguing that there's a strong likelihood of confusion that consumer might think that these Hermes bags, when this is not the case, and that Hermes might actually be behind the issue of these NFTs. Whereas on the other hand, the US artist is claiming that the First Amendment applies and these are works of artistic relevance. So we do have a memorandum order that was issued in May, which seems to be pointing into Hermes' direction, saying that virtual goods might actually be capable of being infringed in the metaverse. So that means that even if registration was only covering tangible goods, these trademarks were actually infringed in the metaverse, which is quite a good news for right holders. The second case is the Nike versus StockX case. In this case, StockX is a Detroit-based marketplace reselling goods, mainly sneakers, online. And Nike sued StockX on the basis that they released a collection on NFTs featuring Nike's shoes without asking their consent. And on the other hand, StockX is arguing that there will be no misleading type of activities in the metaverse, and Nike's rights are actually exhausted. So we will see how this case plays out. The third and last case that I wanted to mention is the Miramax case versus Quentin Tarantino. So here we have, again, a different issue because IP questions are very much related to contractual issues. In this case, Quentin Tarantino is the author of the script of the well-known movie Pulp Fiction. And he decided to release NFTs featuring original footage of the movie. So Miramax, on the other hand, is the movie distributor. And between the parties, a contract was signed about 30 years ago about the rights that Quentin Tarantino might own in the future with regard to the script. And according to this contract, Quentin Tarantino would own the right to print publication, also through electronic formats. Whereas on the other hand, Miramax will still be the owner of the footage. So now the question is, how do we interpret that contract in light of the metaverse? And defining the real nature of NFTs with regard to this specific case would be the key to resolve the case. So as we've seen, this is quite a case-driven space at the moment. So we will see an increase in registrations as well as an increase in infringements, and therefore case law will be our main guidelines for the time being. And some of the questions that we would hope will be answered in the near future are questions in regard to territoriality and jurisdiction, as well as how do we implement in practice court decisions on the blockchain. So these are quite relevant in practice when we look at it. And in terms of registrations, well, what I would expect is that we would see an increase in trademark registrations, possibly in the space of non-traditional trademarks, as well as design registrations, which might actually provide a broader scope of protection. We will possibly see in the close future a change in the NIST classification, providing a more detailed protection for trademarks in the metaverse, as well as an evolution, probably in the long run, an evolution of similarity tests, the targeting test. In terms of authority, as we've seen, one of the main issues is that there's really no one to complain to. And I would expect new authorities to be set out, and a new role of existing authorities as well. And we are already seeing here in the UK an active role of the advertising authority. So for the time being, we do have quite an active role played by the platforms themselves, and possibly the notice and takedown tools will develop with time. So I do hope that this presentation provided some food for thoughts, and if you have any questions, we might be able to discuss it later, but feel free to email me. So much. Let's now move on to Arim's presentation.
Thank you, Serena. Such a wonderful presentation. Let me just share my screen. Hi again, thanks Serena and Samantha. Today I'll speak about use of competitor trademarks as keywords, meta tags on the internet, which is Web 2.0 and in the Metaverse. Since keywords and meta tags are born in the Web 2.0, firstly I will talk about what are keywords, meta tags, and their use in Web 2.0. So keywords, what are keywords? Keywords are actually words and phrases that people type into a search engine to find out something they are searching for. Keywords cause a certain website to pop up when you search for something, and people just use them to reach out their questions. As for meta tags, they provide information about the content of the web page, so they are not visible on the website, but they are enclosed in the HTML of the document. Search engines use meta tags to understand additional information about a certain web page and use them for ranking purposes, which everyone wants their website to pop up first when people search for something, which is very important for the advertisers. So let's look at the case law in the Web 2.0. As the keywords and meta tags were born in the Web 2.0, their implementation will be very much likely in the Metaverse as well. So understanding the context in the Web 2.0 is important here, right? In the first case, the case was between Google and Louis Vuitton, in which Louis Vuitton's trademarks, Google was directing the users to websites selling imitations of Louis Vuitton's products under the heading of sponsored links when Louis Vuitton's trademarks were searched into the engine by anyone. So Louis Vuitton claimed trademark infringement and stated that this causes, firstly, this causes risk of confusion, and secondly, this also causes advertising of the counterfeit goods. Both the regional court and the Court of Appeal stated that Google was indeed guilty for causing such confusion risk and commercial disadvantage for Louis Vuitton, and decided that Google was causing trademark infringements. After the case was brought before the Court of Cassation, they asked the European Court of Justice for a preliminary ruling stating if Google could be prevented from using a trademark keyword or otherwise held liable for such activity. After the European Court of Justice evaluated the matter, they stated that they referred to the passive role of the Google indeed and stated that here a referencing service provider allows its clients to use the signs, but without using those signs. So they only create the technical conditions for other people to use the sign as a keyword, but even though they are getting paid for that, it does not mean that they use the sign itself. So the European Court of Justice, by stating to the passive role of the search engine here, decided that Google was not indeed conducting a trademark infringement against Louis Vuitton. And we see that here the Court of Justice applied a similar approach as if in the safe harbor principle. In the second case in USA, this was between Designer Skin and SL Vitamins. Here, SL Vitamins was using Designer Skin's trademarks as meta tags and keywords to inform the consumers that they sell Designer Skin's goods. Indeed, they were selling genuine goods of Designer Skin, but they were also selling other competitors' trademarked goods as well. So Designer Skin claimed trademark infringement against SL Vitamins and stated that the use of their trademark as keywords without their permission causes trademark infringement. The court stated here that there is a distinction between using trademark to describe the content of their goods and for directing the consumers for competitors' goods. Here, even though SL Vitamins was selling competitors' goods as well, they were indeed selling genuine Designer Skin goods, so they have the right to inform the consumers about their content, so decided that there was no trademark infringement here. In the UK, the case was between Lush and Amazon. The case here with that Lush products were indeed not available on Amazon, but Amazon was using Lush branded keywords in 3 types. The first one is directly using the word lush as keyword. The second one is predictive drop-down menu, which means that when you type LU, the predictive drop-down menu suggests lush directly to the consumers. And the third one is not showing any lush trademarks, but showing other companies' similar products. As you see in the right, Lush is very famous for its bath bombs. So in the third type of this keyword, you don't see any Lush trademarks, but you see other branded bath bombs. Here, the court evaluated the matter in these 3 types of use of keywords and stated that for the first and the second users, there is trademark infringement because the average consumer seeing the Lush trademark on the website would expect to find Lush products indeed. So there is an adverse effect on the origin function, and this causes trademark infringement against Lush. But as for the third use, showing other competitors similar products does not constitute trademark infringement, as the average consumers would also expect any sponsored links to occur for other brands' similar goods. In Turkey, this decision is from 2016. There were 2 competitors, Tatil Sepeti and Tatil Budur, which means holiday basket, and this is holiday in English. Tatil Budur was using Tatil Sepeti trademark as keyword. So when you search Tatil Sepeti in Google, Tatil Budur's website was popping up with the term ads on the link. When Tatil Sepeti claimed trademark infringement, the court stated that even though the average consumers can see the word ad on the link, this would not prevent the confusion risk among the same, and indeed this caused a trademark infringement. There is only an exceptional rule that the Supreme Court applies if the distinctiveness level is rather low in the trademark, such as in the exceptional case I stated here with. There was a trademark, Bursa cartridge. Since Bursa is a city in Turkey, the Supreme Court stated that when people search a cartridge in Bursa, they should type this keyword in the Google. So use of the same does not constitute trademark infringement, even though it is registered as a trademark before the Turkish PTO. So we see that the Supreme Court held a distinction between commercial use and also promoting your trademark for against a competitor's trademark or for your own commercial purposes or descriptive purposes. Both these cases were dated 2016, and then in 2017, the new Turkish IP code entered into force. And we see that there's a very specific article about use of a trademark as keywords in a commercial use is prohibited by the code explicitly. So we see that the lawmakers followed the approach of the Supreme Court and prohibited the use of a trademark keyword in a commercial way. So what about Metaverse? As Samantha and Serena already discussed, Metaverse is not something only we browse, but will be something we live in. While Web 2.0 was something we only browse, but today Metaverse will just have these 2 dual personhood spaces where we will have a digital avatar, but this will also have an impact on our physical being, as if our digital avatar will go into a shop, will search for something that he or she likes, and then will purchase something, or even will be able to ship that visual product to its physical address from the physical store. So these 2 personhoods will combine into one with time. So what about the keywords in the Metaverse? As they did in Web 2.0, keywords will still have a significant place in Metaverse as well. And in the internet age, Google was currently dominating the search landscape. But the next decade is going to be focused on getting found in the Metaverse. So how will you find something that you look for in the Metaverse? While there are currently marketplaces that you can type and search just like we do in Google, there will be Metaverse-based search engines, and Lighthouse Labs is just working on the same, which is expected to be released at the end of this year. So the difference between the search engines we are used to and the search engines that Metaverse will have will mainly have the difference of visual search, because while we can still have the type and search in Metaverse, we will also have the visual search option. And according to the Google Lens, Pinterest Lens, Meta Retailer Visual Storefront, we see that visual search will have such an impact on the following years, and this will also have a huge effect on the consumers. So what will be deemed as trademark infringements when keywords or meta text are used on Metaverse? Actually, while there is still no precedent that we can refer to, all the doctrine says that the criteria will be common with Web 2.0, which means that we will look into if there is a commercial use, if there is an unfair use, fair use, misleading use, or descriptive use. The common criteria will still likely be the same, but the actions may be different, as Metaverse has, as Serena also told, we currently have some problems with the authority in the Metaverse platforms. Who will be the authorized authority, and if the central authorities will have responsibility in the trademark infringement? Will they have notice and takedown procedures? How will we get in contact with the owner of the avatar if we see a trademark infringement? These all remain as questions in the Metaverse, but we suggest for the brand owners to have a regular monitoring in the Metaverse platforms, and especially in Metaverse-based search engines in the future, so that they can have a close lookup in potential trademark infringement issues, and also follow up the search guidelines of these platforms to make sure that they have a notice and takedown or other measures that they can take, because as we all know that trademark infringement lawsuits take much more longer, and they are very expensive. So users, especially young users, will be will have the forced to enforce their trademark rights, when in Metaverse they will look for much more faster solutions. So we will see how the Metaverse will evolve as with keywords and meta text. And thank you for now. If you have any questions, we will have a Q&A session, but also I will be glad to answer your questions. You can email me whatever you want.
Thanks a lot, Irem, for the great presentation. And thank you so much for all of you very actively participating. And we see a lot of good questions in the chat box. So unfortunately, we have just a very short time before the next session. So maybe we can address one of the questions. And I think there are quite a few questions to Serena in relation to the enforcement of the Metaverse. Is there any input in relation to, well, what are the potential issues of enforcement from a procedural standpoint? And also, how do you see the possibility of metaverses to set up mandatory ADR to be used for conflict resolution within their systems?
Yes, thank you, Roberto, for your question. These are exactly the type of issues I was mentioning before, and we will see, and brands will face questions from a procedural point of view, especially when it comes to identifying the infringers. And as I see it, I feel like, we might be leaving what other professionals lived before us 20 years ago, when the online world came up and they did not know how to identify someone, that registered a certain domain names, or he was operating a certain website using their trademark online. So I do see that we will face, that type of issues again. And of course, there are investigations that might help to understand who's behind a certain IP address or who's behind a certain transaction. So we will see, new tools developing, and it is, really what we're looking for at the moment. In terms of, understanding if there might be a mandatory ADR, well, possibly. I do think that new tools will develop, and if there's if there's a need to avoid or to minimize the referring to the judicial system, that might also be an option. So why not?
Yeah, I think it's also very interesting, similar to when the internet and domain names came up, like the ICANN system, and the centralized type of dispute resolution can be set up. So I think this will move on and be developed as the metaverse space is developing. Another question from Jude about can digital assets be created by the users, especially in Web3 metaverse? If yes, how would it be? So digital assets can be created by minting, minting an NFT, but at this point, I personally is not very aware that users can actually mint their NFTs in the platform, but users can actually like anyone can mint their own NFTs separately, but maybe that might not be an asset within the Metaverse platform, and that will be the communication between the Metaverse platform, the developers of the Metaverse, to see whether they want to collaborate with certain users to create certain NFTs. But in the popular Web3 spaces now, the NFTs are controlled and issued by the Metaverse platforms themselves. So thank you so much for all of your questions. And I think we don't have enough time to answer all the questions, but we will definitely take this offline, and do email us for further discussions, or we do have a WhatsApp group for all of our young members, so we can continue our discussions there. So without further ado, we want to pass on the session to our second session. So thanks a lot. Pass it on to Debbie.
Thank you, and thank you again, Samantha, Serena, and Iram for that excellent first session. We're going to hop straight into session 2, and if you're just joining us, welcome again, and thank you for joining us. So for session 2, we are sort of crossing across to our 2 speakers who are based in Europe, and we're going to be talking about licensing frameworks, SEPs, open source, and open standards. And so for this session, we have 2 speakers on our panel, and I'm going to just briefly introduce them. The first is Dr. Niklas Gajak. He's a senior associate at Noir in Germany, and he is from their litigation team. He joined there from a major US law firm in the year 2020. Niklas litigates a wide range of complex patent disputes, particularly in the field of standard essential patents. His knowledge and experience also goes across adjoining fields of law, such as competition and the protection of trade secrets. He has a doctoral degree in the field of trade secret law, and he often speaks frequently on all issues surrounding trade secret and patent protection. He is a member of AIPPI's Standing Committee on Standards and Patents, and is involved with several other IP law organizations as well. So good morning, Niklas. Secondly, we have Jimmy Ahlberg. He is Director Open Source Policy of Ericsson in Sweden. He has worked with open source and open standards and their associated legal frameworks in various contexts within Ericsson since 2014. He's currently working in Ericsson's open source program office within the Ericsson CTO office. He's a board member of and deeply engaged in OpenChain, the international standard for open source license compliance, and is also chairing the Telco working group. His particular focus is in the intersection between open source and open standards. In terms of his educational background, I'll share a snippet that Jimmy provided, in which he says, I have a law degree. I was young, dumb, and Suits was on TV at the time. So despite my best efforts to avoid the profession, here I am. So he has a master's in law. So good morning to you, Jimmy. So I'm just gonna hand the time across to these 2 excellent speakers that we have ahead of us, and Niklas will be starting us off.
Thank you, Debbie, for the kind introduction. Let me just quickly switch to my slideshow.
Yeah, and just while we're doing that, I'll just remind everyone, if you've got any questions, just feel free to put them in the chat at any time during the session.
Okay, here we go. This should be it. So we're gonna jump head into the licensing of essential patents. And what I'm gonna do is I'm gonna deep dive into the licensing and litigating part of it at once, because it's very connected. First, let's start with some basics. So when we're talking about standard essential patents, we're of course talking about patented technology, but we're also talking about standardized technology, meaning it's incorporated into a technical standard by a standard setting organization. And we'll come to the implications of that has both in the licensing space as well as on the litigation side in a second. Implementing these standards is often necessary to participate in a market. Just imagine, for example, the Wi-Fi standard or LTE. So by using your phone, you're committing to a technology that other phone operators are using as well. On the contrary, if you're not allowed to use the technology as a participant in that market, you will find it hard to sell your phones. So obviously, SEP holders, the people who actually own the technology, who have patents that are necessary to implement that standard, are very powerful, and they control the participation in the market. For example, as I mentioned, my last bullet point here, they are a gatekeeper. So coming to litigation, how much SEP litigation is there at all? There's a European Commission expert report, and the expert report cites a rather old source. But according to this elder source, there was an amount of about 3% of declared SEP families that were actually litigated. And considering that number, 3% sounds rather low. But you also have to keep in mind that these 3% represent portfolios. So usually if you're trying to license your portfolio as a SEP holder to an implementer, you're not litigating all of your patents, but you're sorting through the portfolio, and you're taking out the most promising ones, and then you're pressing a few lawsuits also to keep costs low. Meaning that when there's 3% of the total of SEPs being litigated in Germany alone, you can expect most of the SEPs actually being at some point sooner or later part of licensing agreements affecting this particular standard, or even a plurality of relevant standards in the relevant sector of technology. So what are the competition law implications? I'm citing mostly European Union law here. So the treaty TFEU articles 101 and 102 are the most relevant here. 101 refers to the most essential provision in probably any antitrust law, which is anti-competitive agreements are, of course, generally not allowed. And a standardization agreement is in principle also such an anti-competitive agreement, as people who are usually selling the same products are coming together, and they're making up their minds on how to create one big standard that puts together all of their products, all of their technology, and to sell that to basically everyone who wants to participate in the market. So for such an agreement to be legal, you have to fulfill a variety of conditions. And I pointed out a few very relevant ones. For example, of course, the standard setting procedure must be transparent, and there must be opportunities for third parties to join the standard setting organization and to take part in the standardization process. For example, if they bring relevant technology. The standard must be in principle non-binding, which is of course relative, because as you can imagine, most companies will find it hard to, for example, build a product that can actually function, can actually be sold, for example, in the smartphone space without using Wi-Fi or LTE. So the non-binding nature might be actually a more theoretical thing. And that's very important, there must be third-party access to the standardized technology on fair, reasonable, and non-discriminatory terms. And that's where FRAND comes in. Already, when it comes to the question, is this standard setting agreement lawful? Or is it an anti-competitive agreement that's forbidden, for example, according to Article 101, paragraph 1 TFEU under European Union law? Similarly, also in other jurisdictions. So, and that's the most important point when it comes to SAP litigation. We have to look at whether or not the licensing agreements that the SAP holders actually present to other people who want to participate in that market are FRAND, fair, reasonable, and non-discriminatory. And that is actually discussed under a different provision, namely under the terms of abusive behavior, which is another category of competition law. And that's the one that we're actually discussing in SAP litigation most of the time. Because once the SAP holder is part of this standard, once the SAP has been incorporated into the standard, or the patent has been incorporated and became an SAP, the SAP owner holds a dominant position. And he is also restricted in how, when, where to enforce that. And if the enforcement is unlawful, is abusive, then he might actually not be granted, for example, a cease and desist for their patent, even if the normal preconditions under patent law are all fulfilled. So the solution for the SAP holder is to present a licensing agreement on fair, reasonable, non-discriminatory terms. Again, FRAND, most important term here, and also the most important point of discussion when it comes to the litigation side of it. So what is FRAND? FRAND is most of all a licensing practice, and there's a lot of precedent. For example, most relevant precedent in the European Union is, of course, CJEU's European Court of Justice's decision, Huawei versus ZTE. There's also a lot of precedent from the German Federal Court of Justice, and most recent ones were two decisions in CISL versus Haier proceedings, FRAND Defense 1 and 2. And according to the CJEU decision that is also binding for the Federal Court of Justice in Germany, there's a couple of essential steps to FRAND. For example, infringement notice, declaration of willingness, an offer from the SAP holder, counter offer from the SAP implementer. And finally, if they can't agree on either offer or counter offer, then the SAP implementer must provide a bond. So he must provide money that secures the SAP holder's claim for the use that the SAP implementer has actually already made of the patented technology. And there is a lot of problems, legal problems, hidden in these seemingly simple steps. For example, you can ask yourself, how detailed do the notices have to be, or the offers have to be? Who bears the burden of proof if that offer is actually FRAND, so fair, reasonable, non-discriminatory? Also, is there another requirement of willingness? That's something that is pushed very much by the Federal Court of Justice. Meaning how much or to what extent are courts allowed to consider how negotiations are being conducted when it comes to deciding whether or not they will grant a FRAND defense, so not allow for a cease and desist because of FRAND reasons. So, and that brings us to FRAND as a litigation formula. So the un-FRAND behavior of the plaintiff may give grounds to the FRAND defense on the SAP implementer side, which means that the implementer may invoke competition law, the abusive behavior of the SAP holder against the SAP infringement complaint. And if that is successful, as said earlier, the cease and desist of the plaintiff is dismissed. Others may be true, so the FRAND defense may not be effective actually when it comes to other claims, for example, for damages, etc. So, and that brings us to the many practical issues that remain when it comes to FRAND licensing. We have seen FRAND licensing is taking place all over in a variety of technology sectors, especially, for example, telecommunications. There will be more sectors and there will be more FRAND licensing when it comes to IoT. We have seen this with cars becoming smart and the great car battles that have taken place in the during the last years, Nokia, Daimler, and so forth. And that might happen to the same extent to your intelligent fridge and so forth. Every device that needs to communicate with other devices is usually using a standard. And that brings us to the big issue, that is that many of the preconditions of the FRAND process, so to what extent has the implementer to participate, to what extent has the SEP holder to participate in the licensing discussions to be FRAND, each on their side. Many of these conditions haven't been decided on a final note. So we can still argue, we will still see FRAND litigation going on, for example, on issues such as widely varying licensing rates. What is a FRAND agreement? What is a comparable license agreement? When is a comparable license agreement actually comparable? We will see costly and excessive FRAND litigation in the sectors I discussed before. We will still fight about the undecided details of the FRAND defense. And finally, a big practical issue that also remains is the actual failure to achieve a FRAND licensing environment that we see in at least some sectors. So we see a huge discrepancy, for example, when it comes to the portion of a product's value that is represented by the 5G standard, which is, according to many licensing agreements we've seen so far, rather low. And for example, to some particular 4G license agreements that are pressed by some NPEs. On that side, we see some NPEs which only hold a couple of standard essential patents being able to actually press rates and get license agreements from implementers that are well above that what other bigger companies might, for example, achieve in the 5G space. So there is certain issues there, and one might say that that is obviously related to FRAND litigation and the risk of for the implementer of getting sentenced to cease and desist. And that might actually affect their willingness to come to a license agreement even more than the actual value of the technology that they will get by signing the agreement. So, of course, little outlook, there's a lot going on in this space, and we've seen a lot of action on the European Union side. There's a new framework for SEPs coming up with the aim to create a more transparent, predictable, and efficient environment for SEP licensing. That is still being discussed, and we will see some first outcomes of that probably this autumn, I suppose. And we've seen similar discussions in the UK. And also there was, for example, in the US, a DOJ draft policy statement, and the older draft policy statement on SEPs and FRAND licensing was actually just revoked. So there's also a lot of movement here. Similarly, we have the action of the European Union against China on the WTO space for ASI and for anti-suit and anti-suit injunctions. That's probably a bit too much, but we can discuss that in the questions if you're interested in how that is going and whether or not these FRAND questions can and how they can be best answered on a global basis. Of course, and that's another feature of layer of complexity that I have not even brought up yet. We will sometimes see FRAND and SEP action in different countries at the same time, affecting the same patents. And then we will have the dominant issue, which court is actually right and how do we resolve this on a global basis. So that gives us some leverage for a later discussion, I guess. And so far so good. So thank you so much.
Thank you, Nicholas. And that was a really great overview and discussion about SEPs and particularly on Friend. And I think that's given us a lot of food for thought. I'll just now hand you across to Jimmy to continue the conversation on open source and open standards.
Great, thank you. And first of all, I'd like to contrast sort of what was just said, because standardization, that's just one way of developing technology, right? Some of it is done under a FRAND regime, some of it is done under a royalty-free regime, but essentially it's sort of a business decision on sort of which terms do you engage in technology development under, right? What makes sense for this particular technology? How do we believe it will be the most successful and spread in the market? For some cases, it makes a great deal of sense to go the standardization route. I mean, for sort of global technologies where interoperability and market adoption is really key for the value, then it makes a great deal of sense to go down the standardization road, such as Wi-Fi or the cellular connectivity standards, such as 2G, 3G, 4G, and 5G. That's just a business decision of those of us that contribute our technology to those shared efforts, those common efforts. You know, how can we be compensated for that, or how should companies be compensated for that? One way of doing that is sort of by FRAND licensing, but a completely different regime for different technology could then be open source. And I'll start with asking the group here, raise your hand in the Zoom window if you use open source on a daily basis. Anyone who does? I'm not seeing any raised hands. Do we have any raised hands? I have a few, 1, 2, 3, okay. Well, I were expecting more. So if I say that for all of those that use iPhones, about 80% of the iPhone software is open source. Would I get more raised hands then? And if we go the same then for an Android phone, it's about 90 or 95%. That software stack is also open source. So all of you are using it on a daily basis. As said, I were fairly certain of that outcome, so I have it here on the slide. So it's really Windows, Teams, Zoom, whatever sort of software you have of any level of complexity, it will contain open source. It's just sort of, if you want to build software at scale and at sort of any sort of commercial reasonableness, then your developers are going to use open source, whether you like it or not. The question then becomes, what is open source? And from one perspective, it's sort of when a diverse group of people from different entities, might be private individuals, might be competing companies, or companies in completely different industry verticals, collaborate on software openly. And you're able to share that software, you're able to redistribute it, you're able to reproduce it and modify it. To me, that's sort of the heart of open source, that it's a collaborative technology development effort. Then open source, it's not this big monolithic thing where we can say that this is open source. Open source is really about, it's a spectrum of things we all sort of agree fall in under the umbrella word of open source. So you will have a set of licenses that are sort of, people agree that these are open source, and typically they grant these rights of being able to use, reproduce, modify, redistribute the software and the underlying source code as well, so that you're able to modify it. So you will have a bunch of licenses. As I said, typically, I mean, you will find any number of this, but there's literally thousands, if not tens of thousands of different open source licenses out there. But the vast majority of all projects are under sort of 10 very common licenses. So 90%, I would say, or 95% is under sort of a set of 10 very standard licenses. So if you want to sort of understand open source in that legal framework, it would pay off to read up on those licenses. That's just a general tip. There's no generally agreed definition of open source. I'd say the one with sort of the most market traction is the open source definition by Open Source Initiative. But it should be pointed out that that's in no way universal. Open source isn't a registered trademark. So it's again one of these community things. How do we as a community define what open source is? And it's not a clear-cut answer to that. So also, before we move into these risk things, also open source to me, it's fundamentally about copyright. How do we make our copyrighted material available for others under terms that they understand, or perhaps more importantly, that they think they understand, so that they can modify it, share it, and redistribute it to others. And when we share software in this fashion, it means that, yes, we get access to software, but it also means that developers will want to share their modifications back. So we can typically divide sort of open source into two parts here. It's the consumption part of open source. That's when we consume open source software. We put it into our products, we modify it, we build further on it, and we release a new product. That's sort of one side of this. And then we have the contribution side. That's when we upstream, i.e. we push out our own modifications or our own source code as open source. All of these things come with certain risks. So there's definitely a risk of security. How do we ensure that what our developers bring in is secure? How do we ensure that there's no fatal bugs? I mean, we've seen that in the past years. There were some really big cases of fatal security flaws involved. But it also comes with sort of risk of in an organization. How do we control what they bring in? It's not enough to know that what we know they bring in is secure. How do we control that? And how do we control sort of that people do the right thing? How do we do compliance? Because all of these, since they are legally binding agreements for us when we use the open source, these licenses are. How do we ensure that we comply with these licenses? How do we organize that and ensure that we have compliance? That's a cost for us that needs to be managed. It's also about IP. So both for copyright and for patents. When we are using and when we are contributing to open source, that comes with sort of certain implications on our patent portfolio and on our copyright. So if we improperly were to use open source, or rather not improperly, but if we were to use certain licenses of open source, that would require us to also share the modifications we have made to that software. When we share those modifications, unless we sort of are aware that we need to do this, we may have very well sort of disclosed trade secrets or things that we were not willing to share with the rest of the world. And coming from a product company, one issue is sort of we don't do everything ourselves. We bring things in from suppliers. How do we control what our suppliers do? And since we actually sell things to our customers, how do we convince our customers that we know what we're doing? This is not going to open source, and our open source use is not going to be a problem for them. Then, of course, we have the contribution part as well. When we are contributing our changes, and there's good economic reasons for doing that, either because we want to sort of take the technology development in a certain direction, or it's just too expensive for us to maintain our own proprietary forks of the open source. We need to be aware of what IP are we putting out there? What IP are we making available? Is that the IP we want to make available, or sort of that we have a controlled way of doing that? It's also about technology leadership. We shouldn't necessarily contribute. We need to be smart about what we contribute with, so that we don't affect our technology leadership, or we use this to enhance our technology leadership. And of course, perhaps more relevant to this group is when we do M&A. Whenever you do an M&A, you're sort of faced with a company's entire history of both consumption and contribution. So that's something that needs to be managed in the M&A due diligence context. Like, okay, what has this company done before? And from having done, a number of these deals over the years, there's always issues, and probably the smaller and sort of more immature the company is, the more open source issues you will find. Sometimes they're big, sometimes they're small, but there's often things that just needs to be fixed before close. Could be compliance issues, could be the fact that they have just combined licenses that are not compatible. So that might be an acceptable risk if you're a small company, but if you're a global company like Ericsson with more than almost 200,000 employees, then that's sort of a completely different risk set and a completely different risk factor that's not acceptable. So all of that needs to be managed and looked at in the M&A context. So IP and open source, as I said, it's fundamentally about copyright, but of course patents are important and implicated as well. So depending on the license and how the license is being interpreted, we could talk about implied versus explicit patent licensing. So some licenses contains explicit patent license grants from the licensor or the copyright owner to the licensee. Other licenses do not. And since most, if not all of the common open source licenses lack choice of law provision, it's going to be very difficult for us to say for certain how one of these licenses should be interpreted. We could say that it's likely to be interpreted this way in the US, but you could have a completely different outcome in Europe, for example, where you have a different tradition of law. So there's a degree of uncertainty here that needs to be managed. And I said open source comes with obligations on the licensee. It's not just that we take something, we can use it, we don't need to care. We need to do compliance. We need to give correct attribution. In some cases, we need to disclose our own source code if we have modified it or if we have mixed it. Contributing to open source projects, it comes with its own set of issues in terms of IP exposure. And open source due diligence is a key part of the M&A process. I think that as an industry, we have probably moved towards being a lot more aware of this and a lot more mature with this over the past, 8 years that I've been doing it. We've gone from it was a niche thing, perhaps it needed to be done. Now I would say everyone is sort of aware of this in the M&A circle, at least in sort of the tech space, and it's being done. And there's new tools and new sort of vendors available for this compared to sort of the landscape 8 or 10 years ago. This, I think, is sort of the awareness curve. And I think this is sort of universal, even if you're sort of, the more you come to learn about open source, this is sort of the curve you pass through. The first stage is really sort of you're in denial that we don't use open source at this company, do we? Or my clients don't use open source. Then you realize that, oh, they do. And there's no policies, there's nothing governing this. This is a huge risk. So you enter the anger stage. Then it's the bargaining stage. Could we please stop using open source? And as I started out with, no, that's just not possible. That's not how you develop software now. It wouldn't be possible to develop software of any complexity if you didn't have open source. Think of it as, if you're a lawyer, you're not going to rewrite every contract from scratch, right? You have your templates, you have your stuff that you have used before, you will recombine it, you will reuse it. The same for software developers. They're not going to rewrite everything from scratch. If there's a library that sort of satisfies their needs, they will reuse that rather than reusing it from scratch, because rewriting it from scratch isn't providing any additional value. So you enter into the depression stage. We need to use this. We're totally screwed on this point. But the good thing is that you will eventually, the more you learn, move into the acceptance stage and realize that, okay, we can manage this. We just need to be smart about it, develop strategies and processes for how we do this. And to be honest, you constantly cycle between this depression stage and the acceptance stage, because you're constantly learning more and figuring out that, oh, we haven't thought about this before. How would we do that? So it's a constant cycle back and forth between those. And I think that's a natural thing. Then also about processes. And as mentioned, I'm involved in OpenChain, which is ISO 5230, the international standard for open source compliance. So there's this wonderful organization have a lot of reference material, a lot of guides for how you could set up an open source compliance program within a company or for a client. It also sort of offers free self-certification, a lot of templates, guides, and materials. So I would encourage people to have a look at ISO 5230 or OpenChain. So it really is a wonderful standard, but and there are companies out there that offers, you know, professional certification towards OpenChain as well. Then, since we are talking about standardization open source, I just want to sort of put them together side by side here and say that they are potentially they could enhance each other, but there are differences as well. So sort of for each and every project, if you have a technology development project, you need to think on, are we best served by taking this the open source path, or are we best served by taking this the standardization path? And for me, the biggest difference is not in the IP regimes. There's certainly differences in the IP regimes. Most oftenly in open source, you will have a mandated royalty-free, while in standardization, you will find either, you know, that you could opt for a royalty-free option when you contribute technology, or for a friend option, or it's mandatory friend. Of course, friend includes royalty-free, so if you want to make your patents available royalty-free in a friend setting, you're certainly free to do that. But typically that's one difference, but I think they have much more in common in terms of they bring technology developing companies together to develop something sort of for the common good that will be used sort of not only by their companies in that little consortia, but hopefully then by everyone. But one is sort of where standardization sets, this is the interoperability requirements. Sort of we collaborate on the requirements so that we can compete on the implementation. Open source skips that and goes straight to the implementation and says the implementation is what makes it interoperable. If everyone uses the same implementation, then we will be interoperable. But it also means that you will compete on products on slightly different sort of areas here. And as Niklas pointed to earlier, competition law is something that have looked at standards and standardization and friend licensing for a long time. However, sort of open source, for me at least, it's this sort of unexplored area for competition law. It would be really interesting to see if that's ought to change. I mean, to some degree, open source is developing things that are becoming very much de facto standards, like the Linux kernel for operating systems, Android for phones, Kubernetes for container management. All these things are de facto standards in the modern world, but you know they're not regulated, and competition agencies aren't looking at that. And I would find that very interesting, sort of see how they would look at that. But with that, I think we could move into Q&As, or if there's none, perhaps we could have a discussion on sort of other differences, Niklas.
Yeah, thank you so much, Jimmy. I think that was really a great insight, and thank you for sort of putting that whole comparison together on standards and open source, and talking about the 5 stages. That was really useful. So it is Q&A time. I'm just gonna, I think there is a question in the chat, and then maybe we'll just take both of you on closing remarks. So the question is from Kevin, and his question is on court selection, and what factors do you observe to particularly consider when putting a forum selection term in an SEP licensing agreement? So we'll start with that.
Thank you, Kevin. Well, that's a very tricky question. It always depends on the client first, of course. Many clients, they prefer a court in their jurisdiction, home jurisdiction. Then what you always have to consider is on whose side are you on? So if I'm on the SEP holder side, for example, I would try to establish a court that is SEP holder friendly when it comes to interpreting the terms of the license agreement, and vice versa, of course, for the implementer. Yeah, here in Germany, I'd say most courts are very implementer friendly. I'm sorry, SAP holder friendly, so it's not so good for the implementers. But that leads to a lot of litigation in Germany, of course, because the SAP holders are suing here. I'm seated in Munich, for example, and the Munich court is also very esteemed when it comes to FRAND matters. They have a lot of experience and usually you have good chances that the front defense won't hold here, I'd say. But that's, of course, a matter of perspective. So to answer your question, first point is client preference, and the second factor is whose side am I on and which court would be favorable to what I want to establish by litigating this agreement if necessary.
Just to chime into that, I mean, in the first instance, that's going to be determined by the assets you have, right? Which foreign counterparts do you have to this patent? And based on that, you can, of course, make a selection. But in larger disputes, I mean, it's seldomly going to be just one, right? You have benefits and downsides to all of them.
Great, thanks. And we've got one more, and that's directed to you, Jimmy. Maybe you've seen it already. It's from Roberto, and he says, thank you for the presentation. From an IP point of view, TRIPS sets copyright as the standard for protection of source code. Do you think that this is working out well? Do you think it's time to think about a different type or kind of IP of protection?
I don't know. I think that parts of it is certainly working out well. Other parts of it perhaps less so. Perhaps one such thing is just the term of it. Perhaps the term is too long to be practical, because you will have extremely little source code in the public domain. If that's a desirable thing or not, that remains to be seen, right? But you will have extremely little source code there, since it's, in most cases, it has not been sort of 70 years since the death of that author. Perhaps you can argue that you will have some of like Ava Lovelace's things from the 1800s there, but certainly sort of the more modern stuff, no, you're not going to have that. And in any case, sort of for companies, I mean, that term is at least for now, it's far outliving sort of the usefulness of any software, right? So perhaps it should be less. Perhaps we should need something completely different, but it's what we got, and it's certainly better than what it could be. So I think it's a fair compromise, but it could definitely be better. It's a flawed system, but I don't have a better solution.
And I guess as someone who's deeply involved in leading the charge in open source, it might be something that you can think about as well. And who knows what the future will bring. You consider these things. I don't see any other questions, and I think we're just right on time on ending the session. So thank you both for your time and for your presentations in this really interesting side of licensing, both from a SEP perspective as well as on the open source side of things. I just want to invite any participants, if you've got any questions or any further discussions that you want to have, please do reach out to Nicholas and Jimmy. I'm sure they'll be more than happy to engage in a discourse with you as well. So thank you both again. And I think we will now move on to our next session on our agenda.
Thank you very much, Debbie. And thank you so much, Nicholas and Jimmy, for the very insightful session just now. So our next session is on the leadership in the digital age. And so as all of us here are young members, we are aspired and are the leaders of our time. And with this time, a very special time with all that is going on around us, making digitalization even more important, and for us to adapt into the digital age, we're so pleased to have Annie and Trevor to speak with us and to share with us today. So first of all, Annie is the Secretary General of AIPPI, and she is also the co-head of the IP department and the head of IP China IP Practice Group, managing the IP team in Hong Kong, Beijing, Shanghai, and offices. And Annie is also very integral part of the Young Members committee and helping us with a lot of setup, and we're so pleased to have her share with us today. And also we have Trevor today with us. Trevor is from the Orchid Partnership, and he is a leadership coach. He is at ICF and EMCC accredited coach, facilitator, and trainer, and he works alongside with individuals, teams, and businesses to support the achievement of the personal, professional, and corporate goals. So I'm sure we will all benefit greatly from the sharing today from Annie and Trevor. So over to you both, and thank you so much.
Thank you, Samantha, for the introductions. It gives me great pleasure and honor to co-present the sessions on leadership in the digital age with Trevor. Now, for those who have joined the Young AIPPI Members Forum during the past congresses, you will have noticed that we always bring along training sessions on personal skills development. And for this summit in particular, we will also like to bring to you another training, this time on leadership in the digital world. So without further ado, now I would like to invite Trevor to give you an overview on what we are going to do, sharing with you in the next 45 minutes. Over to you, Trevor.
Thanks, Annie. Well, a real warm welcome to all of you, wherever you are in the world. It's a real privilege to be working with you for this next 45 minutes. And Annie and I have put together a really interesting session for you. We hope this is going to be meaningful and it's really going to help accelerate your careers. So what are we going to talk about today? Well, the learning journey for the next 45 minutes is based around these 4 questions. What are we going to cover? Well, we're going to cover leadership, and we're going to focus on, this is a fundamental skill that all of us need for our careers. And the more senior you get, the more important it is. So everyone here is already a leader. So how can we accelerate your leadership journey? And not just there, but in today's environment, this digital way that we're working. You know, right now we're on this. Who would have thought we'd be doing this even just a few years ago? So here we are in a new world. Why are we doing it? Well, leadership is a key benchmark for becoming partner, senior partner, equity partner, whatever it may be. I work a lot with lawyers. It's a privilege to coach lawyers to move from become a partner, for example. And almost every firm I work with, leadership is a key benchmark. And now, how are we going to do it? Well, Annie and I are going to share with you a leadership model, and we're going to ask you to have an anonymous poll on where you score yourself as a leader. So please participate in the chat box. You'll see that I've already posted a question there. So please share your thinking. What is leadership to you? Please just put your thoughts in there. Leadership is all about collaboration as well. So it's a test of your collaboration right now with your colleagues around the world. So we're going to share some ideas, some of our thinking. We're going to have a chat ourselves. Annie's going to share some of her thoughts. I'll share some of my thoughts. So the last question here on this slide, what is the outcome? Well, we want you to be a better leader. So we want you to have action steps. We're going to talk about what you can actually do in the real world to become a better leader, not just at work, but across your whole life. So we really hope you're going to enjoy this journey. And thank you for those who are already starting to share your thoughts. So here we go. It's the first question. Like, what is leadership? It's a fundamental starting point. And thank you. Please just keep adding your comments in the box. So that's wonderful. I see some comments coming in already. Before we do that, Annie, I'm going to turn to you. I'm going to ask you, maybe a fundamental question that crossed my mind is that, are leaders born or are they made? What's your thinking?
Yes, a lot of people ask this question. So, to me, I don't think, this is a binary answer to whether you are a leader, born leader or not. I believe that the leadership is a spectrum. So, and it is up to ourselves. So whether we wish to move along, move up or down this spectrum, or whether we would rather to stay static and be happy where we are. So I think this is something, that we all have in ourselves, and whether or not we wish to bring it out and use it and to apply it.
Okay, that's interesting. So it sounds to me like when you say people choose, it sounds like it's a purposeful thing. It's something you've got to concentrate on, in terms of a skill, in the same way that you have to constantly keep your legal knowledge up to date, your IP knowledge up to date. You've got to keep your leadership skills up to date as well. Am I hearing right?
Yes, absolutely. And then so it should be like a journey, as you put it, and then it should be a moving journey as well.
Thank you. So talking of journeys, you'll see this slide here. We put up a picture of what we think it's all about. So here, this is you, and maybe with your coach. I'm hoping you have a coach, right? So, or if not, an internal coach, someone you mentor with. And here you are climbing up the mountain of your career. And when you start off in the bottom of this mountain, the valley, it's much warmer. So you can have shorts on, you can have a t-shirt, and you can have a rucksack with lots of different equipment. But as you start to climb up your career journey, so you come from being an intern, maybe you move up to becoming, a junior counsel or something along those lines. As you walk up here, you've got to make changes, you've got to adapt. And as you get towards the summit, so as you start to become, a leader in your organization, maybe you become a partner, maybe you set up your own firm, you've got to change, you've got to adapt, you've got to take on board new skills way beyond just your legal knowledge. And one of those obviously is leadership. So let's go and see what some of you are saying in terms of the chat box. So let me first go. Maybe Annie, if you could just run your eye down some of these as well. A big shout out to Jimmy. Thank you, Jimmy. The first person to comment. I think that deserves an emoji for Jimmy. Leadership, communication, and vision and inspiration. Yes, thank you. I would definitely agree with all of those. Annie, does anything stand out to you?
Yes, I think they, there are many very good comments, and I think they all, surrounding the same theme as, someone who must have the skills, and then plus the inspirational ability to influence other people. So I think we're going to talk a little bit more about inspiring others and helping others later on in this session.
Yes, thank you. We've got a model for you, which we're going to talk through. Just a couple of standouts to say, I've noticed here you've got Isadora, thank you for sharing. Leadership for me is knowing your team. Yes, definitely, because you have to adapt as a leader. You adapt to the people. When you go fishing, you bait the hook with what the fish likes to eat, not what you like to eat. So it's making the best of all your people in this, so they can achieve good work. Yes, nice one. Annie, anything else stand out there for you?
Yes, and I also very like, I think Jimmy wrote this as well, is don't confuse being first with leadership. I absolutely agree with this one. So, and leaders, and then we also need to have like a humble characters and be willing to learn from other people, even though they may be more junior than ours.
Yes, absolutely. This whole idea of servant leadership, serving your team, serving your customers and your clients, whoever you're involved with, the regulators, whether it's corporates or individuals, this whole idea of servant leadership is absolutely crucial. The old style of leadership is very much faded away, what you might call sort of World War II form of leadership. That's not relevant anymore. It's all about servant leadership, soft, influencing without authority. All those kinds of things are really absolutely crucial. So thank you. We are going to come back to these comments, but there's some wonderful there. And thank you so much for sharing everything so far. Just like to say, before we move on to our model, is that one of the things that stands out for me is that a leader is the sort of person who understands the difference between management and leadership. So there's often a little confusion here. So for me, management would be, go back to our picture, management is all about climbing up the mountain in an efficient way. That's, to me, is management. Leadership is saying, hey, are we even on the right mountain? Okay, that's what the leader does. The leader is willing to challenge and think differently. So when something happens, like, for example, interest rates have just gone up. Okay, how does that affect your partnership? How does that affect your practice? What's the impact on clients? That's what leaders start to do. They think way beyond what's in front of them. They think slightly differently. So, okay, Annie, any further thoughts before we move on to the model?
Right, I think we should now move on to the models and then just look at how other people may look at leadership as a spectrum.
Great, thank you. Well, here's our spectrum for you. The first level of leadership, according to this model, which is by leadership guru John Maxwell, and he's got these 5 levels of leadership. So what we're going to be doing is asking you later on to vote anonymously on where you are. Now, if you all say 5, I'm not going to believe you. So if you all say 1, I'm not going to believe you. So let's see what comes out of this. So first of all, is your position is level 1. Annie, what does that mean for you in IP?
I think, yes, so this is the general model, for leaderships in all industries. So if I may help to, our audience to relate more to their own, environment, then of course, for positions, you're probably made partners or senior associates, or in some firms, they're called managing associates. Someone which people in your firm will look up to, someone with power and authority to make certain decisions within a firm or organizations, because these powers comes with your positions and with your title. So that's the level 1 of the leadership.
Thank you, Annie. But the thing is, that's like being in the military. People follow you because they have to. They're not following you because they want to. So how do we get people to want to follow us? Well, the next level of leadership is what you might call your credentials. Okay, these are the things that you maybe have clocked up in your career along the way. So, Annie, what would that be in the real world?
Yes, so in coming back to the terminologies that we'll all be familiar with, I think to get your credentials in our industry mean that you probably build up a reputation of some special skills. Say, for example, you're a predominant patent, copyright, or trademark litigator, or you're leading practitioners in some special areas, just like what we've heard, SEPs, franchisings, and clients and other associates would like to work with you, work under you, or work in your team. I think this will be the kind of credentials a second level leaders need to have acquired.
Okay, so what we're saying is people start to want to work for you as opposed to having to work for you. We've all had bosses that we kind of don't really like working for, I'm sure, but here we're trying to get people to want to follow you. And the third level of leadership is really interesting. This is where you start to clock up achievements that maybe in your practice, in your company, in your firm, or your business. These are the things that people get to hear about. Everybody knows about something that you've done. What examples could you give, Annie, just in the IP practice world?
Well, I think in our world, we always talk about financial performance, right? But of course, I think in terms of achievements, it's not just about financial performance, which talking about the new clients you're bringing in, the new cases, the portfolio that you bring into the firm. But I think we also need to look at the other non-financial achievements. These could be something like you're building infrastructures or procedures for the team to achieve, maximum efficiencies. I just give some example here. You're building or improving your case management system, your document or evidence management systems, or even building know-how for the team. I think these will be some of the non-financial achievements that we will look at our leaders to be able to take the initiatives, make things happen, as you put it, Trevor, and then so that people can see you're not only focusing on one and the only one financial targets as your ultimate goals, but then there are other things which then help and to accelerate the level of financial achievements as well. So,
thank you. So what you're saying is that obviously financials are important, and of course, if you land a big client or if you generate fees, then of course that's going to stand out in the firm. But it's way beyond that, because I've worked with some partners who generate fees, but they cause absolute chaos. So it's not just about fees, okay? It's about be way beyond that, and that's some great examples there. Now, those of you looking at this slide will see there's a dotted line. The reason we put a dotted line is there because up to this point, you're kind of just doing your job. Now, even though some of these things are quite difficult and they are magnificent achievements, I'm sure you've all got first-class law degrees and so on. But actually, to some extent, this is like a hygiene factor. It's like standard because that's what everybody kind of expects you to do. So there's two more levels that really accelerate your leadership. And I'm going to talk about them right now. And later on, we're going to just give you some tips on how you can actually get there. But again, please share in the chat box. If you've got some ideas, we want to hear them because there's a lot of collective brain power on this call right now. So let's look at level 4. Level 4, as I mentioned a little bit earlier, and Annie did too, is about serving other people. It's thinking beyond yourself. It's thinking beyond your own world. It's looking in a broader fashion, and it's thinking about serving other people, investing in other people, helping other people in your team and your clients and the practice as a whole. Annie, what examples would tick the box in this category?
As you mentioned, I think level 4 is not about you yourself anymore. It's about the others. So apart from leading your own team, you are also taking up certain responsibilities within the firm or organizations. And you're spending time not just for your own achievements, but for the achievements of others, other team members or other teams and other people in the firm. So, for example, you may be serving in your management committee, or you're looking after the professional development of the whole firm, helping others to pursue their career paths.
Yeah, that's great. So really what you're saying is investing in others, being a bit unselfish and starting to think about the greater good for the practice as a whole. Yeah, that's wonderful. The 5th level of leadership, I wonder if all of you can guess what it is. The 5th level is really taking you to the moon. This is all about thinking like you're leaving a legacy, or rather legacy thinking, which means you're thinking way beyond yourself. You're thinking about the long-term thinking of the practice, the long-term career. I might suggest possibly it's thinking about developing successors. It's thinking about, you know, the long-standing, the markets that you're working in. You know, what new markets might you think about working in? So, Annie, what would be an example, maybe in right on the coalface of what this could be in IP?
Well, I think it's not just about IP, but I think in any organizations or, you know, like a law firm generally. Here, I would like to invite everyone to think about those at the top of your organizations. And then say, for example, the managing partner or the head of your departments. Think about them. You know, people look at them, their achievements, not by how much clients they bring. Of course, that this is a given, and how many clients you bring in the firms, how many new recruits you're going to get, how many talents that you're going to retain in your team. But their achievements are actually measured by the way of the achievements of the department of a whole, or the firm as a whole. And so their priority is to keep the legacy of the department or the firm, to groom new leaders so that this legacy can be continued. And then the new leaderships will be able to run a successful business even when they are gone. So I think these will be their priorities in order to be, like categorized as, the legacy type of leadership.
Yeah, thank you. Now, what stands out is that you all might be thinking that this is something only the senior partners maybe are going to be thinking about. Number 5 is only what senior partners do. That's not true. The sooner you think like a senior partner, the quicker you're going to be a senior partner. Okay, so it starts right now, no matter who you are, where you are, no matter what position you're in. The sooner you start thinking like level 4 and 5, the more likely you are to accelerate your career, because your behavior will reflect that. People will see that you're able to do it, and you're more likely to get promoted. Okay, so what we're going to ask you to do is, I want you to right now, I want you to think to yourself in your mind, where do you think you are on this scale? Okay, in a moment we're going to do a vote, but there's one more thing that we're going to look at before we do that. But just think about this is an honesty session because it's anonymous. Where do you honestly think you are? Okay, I know where I think I am, and I think Annie might think she knows where she is, but where do you think you are? Okay, and let's just quickly go to the chat box as well before we move on, because I'm seeing some wonderful comments coming here. Let me just pick up on one, and Annie, I'll turn to you, and maybe you can pick one as well. You've got here, IREM mentioned enabling others to realize their potential. Yes, that's really good. It's helping others to release them. And so it means investing time in other people to help them to grow as a leader as well. And that does demonstrate leadership. Anything for you, Annie?
Yes, I liked the comments made by Debbie, because knowing when to take the lead and when to let others take the lead, I think that's very important, because even though we are leaders, we don't necessarily need to know everything in the whole world. And there must be times when other people has better skills than we do. And then as a leader, we must be able to let go and allow other people to take the lead when obviously they may have better understanding in the subject matter or something like that. So willing to allow others to lead, I think that is a very important element to be level 4.
Yeah, thank you. And Jacqueline's made a good point there about I'd love my legacy to be that every Australian is familiar as property. Thank you. Looks like, could you please put your mute on, whoever that may be? Thank you. But that's wonderful that you're thinking this way. So this to me is really good evidence of leadership. Let's move on. Now, we're in a new era, and there's been a game changer, in case you hadn't noticed, that we had this game changer, which is the last 2.5 years or so, everything's changed. And I doubt it's going to go back as it was. Annie, what's your thinking about this digital age right now? What stands out for you as the kind of dynamics that we've got to grapple with at the moment?
Yes, this is a question I've been thinking a lot lately, because as you said, there's been a game changer. It turns our world completely to a different directions or different paths. So the way that I put it is will there be a new recipe for leadership? Because in the old days, we've been looking at our predecessors, the people who we were our like the supervising partners. We've been following. It's a kind of like apprenticeship kind of learning to become like the leaders of our own team. But then in the digital age now, we don't really get to see people much in persons, and then so there are limited time we can spend together in person. So is there going to be a new recipe? We what we've seen like other successful leaders have done perhaps will no longer be the right recipes or the right ingredients in the future. So what are we going to do? So this is something that has been in my mind, and I think that there are new challenges which requires and demand new mindset and additional skills of leaders.
Yeah, because it's very much seems to be that we have to embrace this new challenge and not just sort of try and resist it, but to embrace it and say, it's an opportunity. How can we use this opportunity for the positive? Now, some of you may be working from home, maybe a hybrid. Even if you get to the office, there might be nobody in the office because everybody else is working from home. So how do we learn these leadership skills that, I'm 56, so when I started my career, everybody was in the office. I learned it from people. So be interesting in a moment. We're going to share with you our thinking on maybe how you can start to pick up leadership skills and demonstrate leadership skills in this digital age. Let's go for a vote. So just I'm going to ask the GS team to pull up a poll. And here we go. Okay, so here's the poll. All right, so please, it's anonymous. So we'll give you a couple of moments just to answer this. Where are you on this scale right now? So just pick one of these, pick a vote. Now I'm going to vote as well. Okay, I've submitted my vote, and I'm just going to give you a little bit more time because the GS team hopefully can see how many of you have voted. So when we've got to a decent number, maybe you can. Annie, I'm going to ask you, where do you think you are on the leadership? How would you rate yourself?
I actually rated myself as a number 4. So at the moment, just what I'm doing, I'm serving others. I'm say, for example, my contributions to the association's AIPPI. So I'm helping, the IP stakeholders, to create a better IP ecosystem, to encourage innovations and creativity. So I see that as my missions and the areas where I'm spending my time. Of course, at the same time, I still have to do, the achievements that we mentioned, in the office. But then I think, I'm gradually moving a little bit more in building up the society, the IP society, and the IP environment.
Thank you. Thank you. Yeah, I rated myself a 4 as well. Can I say, actually, you're being quite modest, because I would have actually rated you a 5, because, for example, you've actually you've volunteered to be the Secretary General. I know you've done some wonderful things in your own firm. So I know you're quite modest, but I can say it, you can't say it. But that's great. Modesty is also a good leadership skill. Okay, GS team, can I ask you just to show the results? Great, here they are. Okay, what do we notice here? Annie, what stands out for you on these scores?
Well, I think this is actually very encouraging, because we're seeing quite a good numbers of our young members who are already serving other people, and this is great, because people recognize that the importance of serving people at a relatively younger age, and then this is going to give you a lot of time to then further develop then your skills to take you to the next level. But of course, equally, there are quite a percentage of people who rank themselves quite modestly in level 1, 2, and 3. But then I think this is quite normal, because you're all under 36, and then so for the past 10 years or so, you've been investing in building and developing yourself to reach to level 3. So I think this is good to to take some time to think about, how am I going to move myself to the next level.
Yes, thank you. So those of you who rated yourself there, I'd like you to think about the number that you scored. I'd like to ask you, in your mind, where do you want to be? Now, of course, I guess 5. Everyone's going to say 5, but I'm asking you to say, well, where do you want to be? Do you want to be, maybe you rated yourself as a 2 and you think you want to get to a 4, or maybe you're a level 4 and you want to get to a 5. Whatever it is, what we're going to do now for the next 10 minutes before we wrap up, we're then going to just talk about what could you actually do to demonstrate in your firm how to get to that next level. So thank you for your scoring, and thank you for your honesty. That's a really terrific result to get you to capture that. Because what we're going to do is get you to think. Now, that's what good leaders do as well. We get you to think, to try to expand your mind, so you're increasing your self-awareness, so that you know what you need to do next. Okay, so we've had the poll. What level of leadership are you? Thank you. We're now going to ask this question, really. And again, we throw it open. If you'd like to share your thinking on the chat box, that would be great. But how do we get to the next level? So what do we do that helps us to become a level 4 leader? And then what can we do to become a 4 to a 5 leader? So Annie and I were talking about this earlier as we were preparing for today, and we were wondering, what can practically be done? Because that's what it's all about. Practically, what can be done to get to the next level? So Annie, what's your thinking on some of the actual positive steps that people can take?
I think the very first things, important one, is to understand your own leadership style. And I think, just now we've done the poll. I think that's is a good time to reflect on, where we think we are at the moment, and then a willingness or desire to move up the levels, so that we have this learning mindset, that we are determined and we are willing to invest time to improve on our leadership skills and to acquire skills that will help us to move up the level. So I think, to transit from a producers, so your own achievements, to help others with their achievements, and to empower potential leaders. I think these are some very first steps to do in order to be able to look at a higher level than where you are now.
Yes, that's right. Now it seems to me that it's collaboration is a key area, because I noticed when working with professionals in the legal profession that they don't often like to collaborate with other practice lines, and I think once you're in thinking level 4 and 5, I think you're thinking way beyond IP. You're thinking, well, maybe this is a key client, so how can we collaborate with, say, financial services team or the property team or the commercial team, so that we work collaboratively and we have a much bigger pie amongst all of us. What's your thinking on that?
Well, I think this is something very important. As I just mentioned, for level 4 and level 5 leaders, it's not so much about yourself, but then the organizations, the society as a whole. So we do need to look beyond, our own desk or our own pie. So it's to grow the bigger pie as a whole. And then sometimes, if we want to then take a leap step upwards, is, like apart from what we are doing for our own financials and what are we contributing to the society, I think that's also very important to look at.
Yeah. You also mentioned here about establishing your own leadership style. And I think one of the great ways to seek feedback, and I noticed that many leaders are not afraid of seeking feedback from their colleagues. They do 360 feedback exercises. They ask people, how am I getting on? And they discuss it with their line manager, etc. What have you seen that colleagues do, and maybe yourself do, in that area?
Well, I understand, the 360 review is not very common in some part of the world. In some part of the world, where there's something, you must do. So when you don't have such a system built in your organizations, then how do you get feedback, from other, your teammates and all that? I think it needs to create the trust. I think here, I think one of the comments talked about, building trust, and I think that's absolutely important. If your team members have the trust with you, and they will come to you and then be able to tell you, okay, so what do they see is lacking in I would not say they're not going to tell you directly, okay, I don't think you're a good leader because you're doing this and this wrong, but then they will give you suggestions on how to improve the environment they are working in. So I think that's something very important, is to have the trust so that people will be willing to approach you and tell you the truth.
Yeah, and also it's good to know truth on, for example, some of the areas, like if you dress like a leader, people think you're a leader, and I think turning up in your pajamas for an online call doesn't really demonstrate leadership in my mind. Being on time, these kinds of things can actually undermine your leadership. So you've got to make sure you're not scoring an own goal, but looking like a leader, behaving like a leader, and actually speaking like a leader. And then guess what? People think you're a leader. It's quite fundamental. What I'm also hearing, though, is it's really making things happen, is in a leadership sense. What examples have you seen around people proactively doing things to demonstrate leadership?
Well, I think one of the things is, to be able to assess risk is very important, because as we just mentioned, then there are so many things happened in this world, and just one thing can perhaps be a game changer of the environment that we are very familiar with, and be able to have that kind of of course, we haven't actually talked about the vision of the leader previously, but then that is put it aside. I think people know about the visions, leaders having visions, but I think in relating back to the topic, is in the digital world, I think the ability to see risk, to identify risk, is also very important. So how leaders will be able to do that is not just, again, to sometimes as lawyers or legal practitioners, we are too much indulged in our own work, and then we kind of like skip what's happening in the world surrounding us. Say, for example, last night I was watching the news, and because of the increase in prices of natural gas, some of the countries are beginning to think of like the older way of producing energy, using coal as a source of producing energy. So what is that going to lead us to? So probably some energy crisis or like an environmental issue. So how is that going to then affect our business? I think these will be the risk areas that we need to as leaders need to identify and be prepared for it rather than being caught by it.
Yes, that's right. So what you're really saying here is that it's thinking much broader, and it's thinking way beyond just your own practice line, looking at the impact of certain things and trying to think ahead and cut things off before they become problems. I mean, they're all great leadership skills. I'm going to turn to the chat box. A couple of really good points have come out that have been made here. First thing is Martin Timmermans. Thank you, Martin. He's asked the question, can you get to level 3 without having been at level 1 and 2? That's a really good question, because leadership, I think, is a skill that shouldn't really depend upon your legal knowledge, for example, because it's a bit like business development is a skill, marketing is a skill, leadership is a skill, management is a skill. So I don't think you necessarily need to have been through all the levels, but I think to have credibility and real solid leadership, then I think you do need to have gone through them in whatever industry you work in. And there was another point here. Jimmy is just saying that leadership's really about getting results through other people. And Annie, I know that you've built quite a big practice in Hong Kong in your IP world. And I mean, how have you developed your people?
Well, I totally agree with that comments, because, like with one person, I only have one pair of hands, one brain in 24 hours. But then if I can mobilize and empower a whole team of people to help in building the practice, building the business, then that will be, like 100 times, 1,000 times more effective than just me, doing things on my own. But of course, again, then go back to your point about collaborations and then, being willing to like allow others to take the credits. So that is, some of the major elements that you will be able to attract people to collaborate with you.
Yeah, thank you. Just one thing I'd like to say before we start to wrap up. We've got about 5 or 6 minutes left, and we'd like to just get you to think about what action steps you might need to take personally as a lead to boost your leadership skills. But obviously, in today's current way of working, hybrid working, or working from home, or possibly a lot more online, maybe we can't see so many people, we don't travel quite as much as we used to. What can we do? And one thing that stands out to me is just literally have a structure and work to a working pattern. Because when you're at home, it's tempting to sort of mull around in a sloppy old t-shirt and that sort of thing, but actually to dress as though you're coming to work and actually reach out proactively to colleagues, check in with people, check in with clients, check in with your teammates, check in with your partner that you work with. Any thoughts on, or closing thoughts on those, Annie, on how you can operate in the modern world?
Well, the thing is that we all facing like competing commitments. So in order to ensure that you will be giving time to, to have this kind of interactions, to promote or to maintain the interactions to a certain level, I think it's necessary to put it down on your diary, because that will be the way to, make sure that you assign the specific time to work with your colleagues. Because, one of the things I'm seeing, if I'm talking about identifying risk, is the risk of, the lesser communications with my colleagues because of, the hybrid working environment that we are in at the moment. So one of the things I'm very diligently, forcing myself to do is to put down a time to meet with colleagues from different departments and different areas, so that it not necessarily we must have some agendas for such meetings or such chats, but then just to say hello and then see how each other's are doing. I think those interactions are very important, which are missing in the Zoom world.
Yes, very much so. Okay, just going to start to close off now. I'm going to just put up a couple more slides to get to think. Just time for reflection. We've covered a lot here. I'd like to just ask you a few questions, just for your private reflection. What have you learned in this session? Now, we've tried to pack in some content, some ideas. What stands out to you? What do you need to do? You might think, actually, I'm not doing that, and I used to do it. Or maybe there's something you need to start doing that you've never thought about doing. Just write them down, because otherwise you'll lose them. Write those down and ask yourself, how am I going to actually apply what we've learned about that? I've got lots of ideas. Annie, what do you think people can do to actually apply this?
Well, we've done the poll, so reflect on the leadership styles or the level of leadership you are on, and then think about what will be required of the leaders in the next level. Identify those areas that you haven't actually been doing or doing enough. Then focus on those areas. I think that will help you to then focus or narrow down to a few things. Then for you to work on it, because if you just leave it and then try to, I'll try to do 100 different things, that is not going to take you anywhere. Better to focus on a few, better than not anything more than 5, then you're more likely to get results out of them.
Yeah, thank you. And I would just encourage you to have a learning plan, write it down. I mean, I have my own learning plan. I mean, in our business, I'm always looking at how I can be a better coach, and leadership is one of those things. I'm currently working on decision making. That's my big topic. So that's my own personal focus area. And what I do is use SMART goals. So SMART goals, I'm sure you can look it up, but basically it's goals being specific, measurable. I call attractive for the A. It's got to be attractive to want to do it, realistic and time-based. So have yourself a learning plan, and that really helps. Okay, Annie, before we wrap up, we've got a minute left. Any closing thoughts from you as the leader in your Secretary General position?
Well, of course, then, I would like to encourage all of you, this 45 minutes is not going to then change you, to different levels of leaders, but start thinking about this. And then I hope to see you all in San Francisco, because we are going to have a gathering for our young members. And if you would like to talk about this more, then please let us know, write an email to Debbie and Samantha or other members of the YAC. Then we will try to see if we might be able to continue with the dialogue in San Francisco and beyond.
Thank you. It's been great for me personally to work with you. Hope it's been helpful. I'll hand back to Annie and the team. But it's been a great privilege. And for those about to lead, I salute you. So thank you. Annie, thank you.
Thank you, Trevor. Back to you, Samantha.
Thank you so much, Annie and Trevor. That's been a fascinating dive into leadership. And I am delighted to invite you to the plenary session number 4, which is on life sciences inventions and rethinking medical use patents. I am Nina Fitzgerald. I'm a partner at Ashurst in Australia, and I practice in commercial and contentious intellectual property law with a specialty in technology and life sciences. I have litigated a significant number of medical use patents, so I'm really looking forward to this discussion today. And I have the great joy of welcoming our 2 speakers. Firstly, Clarissa Regler is a patent attorney in Germany at Winter Brandl and specialises in the field of biotechnology and chemistry. She has a master's degree in pharmaceutical bioprocess engineering at the Technical University of Munich, And Clarissa is also a committee member of the AIPPI Standing Committee of Biotechnology. And then following Clarissa will be Jiri Slavic, who is dual qualified Czech and European patent attorney and a European design attorney based in Prague, the Czech Republic. Jiri has more than 7 years of experience as an in-house patent counsel in the pharmaceutical industry and is currently working at Adalvo, which is a leading business-to-business pharmaceutical company and part of the Avolgan Group. He also has a scientific background in chemistry and became a young member in 2021. So I'll hand over to Clarissa now to give her presentation.
Okay. So I hope you can see it. Just share my presentation. So thank you very much for the kind introduction. It is a pleasure to be part of the AIPPI Young Member Summit, and I'm very pleased to give you a brief overview concerning life sciences inventions under the EPC. So under the EPC, which came into force in 1978, it was possible from the very beginning to protect life sciences inventions. However, there had been a legal uncertainty regarding life sciences inventions till 1989, when the European Commission realized the fear that some European countries might respond to biotech patent controversy by simply banning patents on living organisms and genes. And therefore, the European Commission drafted a directive on the legal protection of biotechnological inventions in 1989 to harmonize the protection of biotechnological inventions of the different EU member states and to clarify the protection allowed to biotechnological inventions. In 1998, the final version of this directive was then adopted, and the EPO has implemented this EU biotech directive. Also, it is not a member state of the EU, and thus it was not obligated to do so. There is no legal definition of the term life sciences inventions in the EPC, but with the adoption of this EU biotech directive, we have rules 26 to 30 EPC, which provides several definitions for the field of biotechnology, for example, defining the term biotechnological invention or biological material. But what does life sciences mean? Generally spoken, it refers to any branch of research in the natural and engineering science that deals with the structures and behavior of living organisms and the application of that scientific findings in modern biology, chemistry and medicine, as well as related fields. The EPO provides a broad range of possibilities for protection of all kinds of innovations in the rapidly developing field of life sciences, under which applicants can obtain patents relating, for example, to plants, plant cells, animals and parts thereof, microorganisms and cell lines, and even parts of the human body. And also in this presentation, I focused primarily on biotechnological subject matter. And the field of life science includes also chemistry, particularly relevant to small molecule therapy or yes. And biotechnological matter usually covers polymeric products such as DNA, RNA, and proteins, or even more complex products such as drugs, where many are antibody-based. So it is really a rapidly changing technological landscape. As you know, Article 52.1 EPC outlines that European patents shall be granted for any inventions in all fields of technology, provided that they are new, involve an inventive step, and are susceptible of industrial application. And Article 52.2 EPC further defines subject matter which is not to be regarded as inventions, including, for example, discoveries and mathematical methods. In the life science fields, the question of such non-patentable matter is of concern regarding patents for products occurring in nature, as well as for inventions relating to the processing of data, for example, in the healthcare field. And when it can be regarded as invention, so when we have a tick here, then the next question is, does its subject matter fall under the exceptions to patentability? Because the EPC mentions in Article 53 EPC several exceptions to patentability, and each exception is relevant in the field of life sciences inventions. So we have here on the slide an overview. Exceptions to patentability based on our public and morality are addressed, for example, in Article 53A EPC, and Rule 28.1 specifies 4 subject matters which in particular are considered unpatentable, namely, for example, processes for cloning human beings. And since it is the generally accepted principle in the interpretation of a law that an exception to a general provision is to be construed in a narrow manner, the boards of appeal have adopted a narrow interpretation regarding Article 53A EPC in numerous decisions. So the basic approach in this regard is, can the subject matter be protected and not can the subject matter be excluded from protection? And according to Article 53B EPC, plant and animal varieties are also excluded from patentability, but plant varieties can be protected under the so-called Council Regulation on Community Plant Variety Rights, which came into force in April 1995, providing uniform protection to plant varieties throughout the European community. And in addition to plant and animal varieties, Article 53B EPC also excludes from patentability essentially biological processes for the production of plants or animals. From the wording alone, it is clear that essentially biological processes are excluded from patentability, regardless of whether the plants or animals produced by these processes are varieties. And finally, biotechnological processes and products resulting from them are often applied in methods for treatment of the human or animal body by surgery or therapy, and diagnostic methods practiced on the human body or animal body, and such methods fall under the exceptions to patentability in accordance with Article 53C EPC. One intention underlying this exclusion from patentability is to ensure that no one who wants to use the above methods as part of the medical treatment of humans or animals is prevented from doing so. As regards treatment by surgery, the enlarged Board of Appeal held in decision G1 of 07 that a method practiced on the human body and comprising an invasive step which might lead to substantial healthcare risk, even when carried out with the required professional care and expertise, is to be regarded as a surgical step which excludes and such a method from patent protection. And in G1 of 04, the enlarged Board of Appeal decided that a diagnostic method is to be excluded from patent protection if and only if the method contains all necessary steps for making the diagnosis, and all steps are performed on the human body. So diagnostic methods which are practiced outside the human body or contain at least one step performed outside the human body, for example, on body tissues or fluids like blood, are not excluded from patentability as diagnostic methods. So nevertheless, even if the invention comprises methods or treatments according to Article 53C EPC, a disclaimer which is not disclosed in the application as filed is allowed to disclaim subject matter which is excluded from patentability under Article 53C EPC. With respect to the morality of protecting biotechnological inventions, relating in particular to transgenic animals and plants, human genes, gene therapy, human embryos and stem cells, recent years have seen very controversial discussions. And just one example, in the so-called Bristol case, the Court of Justice of the European Union defined that an embryo starting at the stage of a fertilized egg and that an invention should be excluded from patentability where the claims are directed to products. In the Bristol case, it was human embryonic stem cells, which, as described in the application at the filing date, could be prepared exclusively by a method which necessarily involves the destruction of human embryos. And that decision is also in line with G2 of 06. And it is interesting to note that the German patent was maintained in amended form by introducing a general disclaimer, excluding the destruction of human embryos. But in the corresponding EP case, the opposition division revoked the European patent by stating that such disclaimer cannot be allowed, since at the filing date, the method necessarily involved the destruction of the human embryos, and it is not of relevance that after the filing date, the same product could be obtained without the steps of necessarily involving the destruction of human embryos. And in the second instance, so the EP patent has been also maintained in amended form, but claim 1 now comprises the disclaimer with the exception of a human. The EPC implementing rule also provides examples for patentable biotechnological inventions, for example, biological material, isolated or technically produced, and plants or animals which are not confined to variety. Taking into account developments after decisions G212 and G213, that was the tomato and broccoli decision of the Large Board of Appeal, according to the recent decision G3 of 19, that's now pepper decision, it is now held that the exception to patentability of essentially biological processes for the production of plants or animals in Article 53b EPC has a negative effect on the allowability of product claims and product by process claims directed to plants, plant materials, or animals if the claimed product is exclusively obtained by means of essential biological processes, or if the claimed process features define an essentially biological process. So, for example, a plant part obtained exclusively by means of an essentially biological process is not patentable anymore. An isolated part of the human body constitutes patentable matter, even if the part in question is identical in its composition to the naturally occurring part, but only in addition to a disclosure of its industrial application. So this is this plus on the right side. Further decisions of the Enlarged Board of Appeal of the EPO show the progress made, as well as the importance of life sciences inventions for the development of the case law and practice of the EPO. One landmark decision is the Oncomos decision, T19 of 90, acknowledging that animals are in principle not excluded from protection under the EPC, and the decision G1 of 98 from the Enlarged Board of Appeals, where it was stated that a claim encompassing plant varieties is not excluded from patentability as long as it does not individually claim these varieties. So a claim in the field of life sciences could be directed, for example, to a transgenic plant carrying a specific gene, and the majority of the plant-related applications filed in the EPO relate to transgenic plants. Transgenic plants means plants which contain a foreign DNA sequence that is normally not observed in the plants. Usually the foreign DNA is introduced into the plants by genetically engineering single plant cells which are then grown to the complete transgenic plants. So for any subject matter that qualifies as an invention under Article 52 EPC, further several criteria must be met to render the invention patentable. The claimed subject matter must meet the patentability requirements of novelty, inventive step, and industrial applicability. And furthermore, the application must fulfill the requirements of unity, sufficiency of disclosure, and clarity. And with regard to these criteria, there are some peculiarities to be considered in the life science field. With regard to novelty, for example, the Board of Appeal made clear that a DNA sequence may only be anticipated by the disclosure of an identical DNA sequence, because even a change in one amino acid can dramatically change the properties of the whole protein molecule. And according to Article 57 EPC, it is sufficient that the invention can be industrially produced or used in order to fulfill the industrial application requirement. And in the last few years, the Board of Appeal have put increased emphasis on the relevance of Article 57 EPC in the field of DNA and protein inventions, though in cases where a substance naturally occurring, for example, in the human body, is identified and possibly structurally characterized, but its function is not known, or no disease or condition has yet been identified, and no other practical use is suggested for the substance, then industrial applicability cannot be acknowledged. In view of the rapid developments in the field of biotechnology, the person skilled in the art in the field of biotechnology is also well defined. His attitude is considered to be conservative. He would never try to enter unpredictable cases or areas, and should be assumed to be a scientist or a team of scientists. And moreover, especially in the field of genetic engineering and biotechnology, the term expectation of success can be found very often. What does this mean? When inventive step of, for example, an antibody has to be evaluated, the subject matter of a claim defining a novel further antibody binding to a known antigen does not involve an inventive step unless a surprising technical effect is shown, or unless there was no reasonable expectation of success of obtaining antibodies having the required properties. So a reasonable expectation of success should not be refused with the understandable hope to succeed. A reasonable expectation of success implies the ability of the skilled person to reasonably predict on the basis of the existing knowledge and before the starting of a research project, a successful conclusion of the said project. So the more unexplored a technical field of research is, the more difficult is the making of prediction about its successful conclusion. Moreover, right now, before the enlarged Board of Appeal, there is the referral G2 of 21 pending, and this referral is also very important for the life sciences and chemistry pharma field, because here we often have questions concerning plausibility. So the main question is if post-published evidence should be disregarded when the proof of the technical effect rests exclusively on the post-published evidence. So with other words, can an inventive step be acknowledged when the patent proprietor relies on a technical effect and has submitted evidence, such as experimental data, to prove such an effect, but this evidence have not been public before the filing date of the patent in suit and have been filed after that date? So that is a question. And finally, as for any other inventions relating to life sciences must be disclosed in a manner sufficiently clear and complete to permit them to be carried out by persons skilled in the art. So the question of sufficiency under Article 83 EPC is an especially important issue for a patent in the field of life sciences. Microorganisms differ from classical chemical subject matter in that they're often not reproducible by a person skilled in the art based on the written disclosure alone. And to overcome this problem of providing a sufficient disclosure for a microorganism, applicants are allowed to supplement the written disclosure by a deposit of biological material. And with regard to Article 83 EPC in general, there was previously a more liberal practice, meaning that an invention is sufficiently disclosed if at least one way is clearly indicated, enabling the person skilled in the art to carry out the invention. So there was a decision, herpes virus decision T127 of 02, and the application contained no experimental data. Nevertheless, the board held that the fact that no specific experimental data are provided does not render the teaching insufficient. This is because there was a problem or difficulty that could have prevented this. There was no problem that could have prevented the person from putting the teaching of the application into practice. And in another decision, it's the UNT decision. However, the board applied the principle of conventional chemical matter, requiring sufficient information reflecting the whole claimed broad area. So a position which has been followed more and more, and emphasizing that broad claims require a broad range of examples to fulfill the requirement of Article 83 EPC. And in the medical field, the question may arise whether clinical data is required in relation to the requirement of sufficiency. And with regard to the medical field, I would like to hand over now to Jiri. So thank you very much.
Thank you, Clarissa. I will try to share my presentation now. I hope you can see the slides now and you can hear me well. So thank you, Clarissa, for setting the scene for the life science inventions. Thank you, Nina, for the very kind introduction, and it's a pleasure to be here today and to have the opportunity to give you this presentation. The aim of this should be to introduce you to the current challenges we're facing in the field of medical use patents, and mainly from a European perspective. This is a rather specific topic, so I understand that some of you might not be familiar with this topic. It's the same as if you talk to me about NFTs and Metaverse, and now I talk to you about second medical use claims if you're not involved in this topic. So I totally understand this. And although there is maybe too much on the slides, I'll try to address the main topics and convey a clear message of what I'm trying to say here. Here, just an obligatory disclaimer that everything that we're discussing here is my personal views and should not be attributable to my employer or any other group. So when do we actually talk about medical use claims, and what are medical use claims? Medical use claims can come in very different forms depending on the country's national laws. Here are just several examples of how medical use claims can look like. We can have a method of treatment claims. We can have the simple use claims. We also used to have, and in many countries, especially outside the EPO or US, they are still very heavily used, the Swiss type claims, which are not allowable at the EPO anymore. And that's why we now have the new EPC 2000 claim format, which is the standard before the EPO right now. Here we also differentiate between first medical use and second and any further medical use. And I will give further examples on that. Here, just to give you a detail a bit that the second medical use claims are really limited to substances or compositions. So you cannot use second medical use claims to, for example, surgical instruments. It really has to be a substance or a composition. And while we have these different kinds of medical use claims, they may be interpreted differently in different countries. So the assessment of patentability, novelty, and of infringement, who is liable for infringement, what are the elements of finding infringement, they all may be different. And here I would like to point out to the AIPPI study question, which was done on second medical use claims. However, be aware that it may be already outdated because it's from 2014. When we talk about second medical use claims, we also need to talk about potential exclusions. And for example, as Clarissa has mentioned, under the EPC, we have Article 53C, which excludes the method of treatment claims at the EPO, and Clarissa has already mentioned that. On the other hand, for example, in the US, the method of treatment claims are allowable. However, then there is the medical treatment defense, where the which exempts the medical practitioners from facing patent infringement suits. And basically, these two ways are just different ways of achieving a very similar result in the end. I also should note that while most of the countries do provide for some type of medical claims that are allowable, there are still countries which do not provide for any format of medical claims that are acceptable. It is an open question whether this is compliant with the TRIPS, because as you know, the TRIPS agreement mandates that the patents are available in all fields of technology. On the other hand, there are several flexibilities under the TRIPS. There is no explicit reference in the TRIPS agreement for having second medical use claims. And there is also this possibility of excluding method of treatment claims. And of course, different stakeholders have different views on this. I've pointed out here the AIPPI resolution stemming from that study question. On the other hand, Some agreements have removed the necessity for having second medical use claims because they are recognized as an evergreening practice. And I will come back to that later during the presentation. Additionally, there are also free trade agreements that are concluded between countries that require its members to implement further types of protection, including, for example, patent term extensions, medical use claims as well. And these are often viewed as TRIPS plus provisions because they go to somewhere beyond what is required actually by the TRIPS agreement. Now, when do we mainly use medical use claims? And here are the examples that differentiate between the first medical use and the second medical use. We talk mainly about the pharma industry. And for second medical use claims, it's the repurposing of drugs, which plays a role for second medical use claims. When you have a known chemical substance that was already used for some non-medical use, for example, as an intermediate in chemical synthesis, or put it more easily as a paint pigment, and you discover that this substance has a pharmacological effect, you can claim it by a first medical use claim, which is limited for this purpose of being used as a medicament. So it's still novel, even though the substance was already known. Yet even more, if the substance was already known as a medicament for treating a specific disease, and it was repurposed for treating another disease. A very famous example would be sildenafil and Viagra, which was used to treat, or was intended to treat heart disease and was repurposed for treating erectile dysfunction. Then you can claim the medical use, which would be second medical use, which would be protecting the actual second medical use, which is different from the one that was known before. So it would be limited to treating this different claim disease. That's why this claim would be novel. And here comes one of the challenges, that we do not have second medical use claims only for truly new therapeutic indications themselves, but often, and this is the case also at the EPO, we have second medical use claims for all other different groups of inventions. We have different dosing regimes, we can have sub-patient groups, methods of administration, subsets of the same disease, somehow more limited. And this creates a lot of confusion and uncertainties, and especially for generic companies, this is really problematic. And although repurposing of drugs in itself represents an important aspect of the industry, and it's important for public good and for treating patients, we should and have to differentiate between contributory inventions on one hand, and on the other hand, on evergreening of patents. And indeed, this was already acknowledged by the resolution of the European Parliament, which I noted here, that there is this need to differentiate between these kinds of inventions. And to give you some examples, here on this slide, I have tried to summarize what I meant by this distinction and what is usually referred to. For the contributory inventions, I've pointed out two very known and infamously known examples. One is aspirin, acetylsalicylic acid, which was used as an analgesic for many years, which was later marketed for prevention of cardiovascular events at low doses. Then a thalidomide example, which is a very infamous example of a substance that has caused very serious birth defects when taken by a pregnant woman, which is now actually used to treat a very severe disease with, of course, all the necessary precautions, but it helps the patients when used properly. On the other hand, we have examples of evergreening of patents. The first example, and I will come back to this example later on, is a pirfenidone drug, which is an anti-inflammatory drug with a basic patent that expired before the MA was received in 2011. And there was a second medical use patent for treating the pulmonary disease with a supplementary protection certificate expiring in 2021. Yet further, there are many second medical use claims, and one of them covers avoiding smoking when using this drug for treating a lung disease, which is set to expire in 2030. Another example we have here is fingolimod, which is used for treatment of multiple sclerosis, where a compound patent together with a supplementary protection certificate expired in 2018. Yet there are a series of second medical use divisionals which cover ophthalmic adverse events, and they are expiring in 2030. Moreover, in this case, it is the case where a new divisional is filed once the parent is withdrawn or refused. So this is another divisional game in this case, which artificially prolongs the patent monopoly. Now, to give you a full picture of how the pharmaceutical and IP industry works, we do not have only patents. We also have something which is called regulatory exclusivities, which reward often for very costly generation of own clinical data and create an objective and statutory reward for getting approval for new drugs. However, the legislative challenge in the EU is that the exclusivities are generally only available for new active substances and not for new uses of known substances. And here is, I don't want to go and bother you with the details of how the regulatory exclusivities work in the EU, but here you can see an overview. And without going into these details, you can see how these exclusivities work, and that from a closer look, you can see that for new therapeutic indication of a known drug, you can get at most 1 year of protection. Therefore, there is on one hand a clear lack of regulatory exclusivity incentives for repurposing of drugs, and companies have to rely, and sometimes, as pointed out in these examples, even sort of misuse the patent protection system, because the patents are the only incentive for any return on investments for doing this drug repurposing. Because in general, they will usually not get any regulatory exclusivities for repurposing of the already approved drugs. There is a pending revision at the European Parliament, which tries to revisit the concept of regulatory exclusivities, and there is need to address the interests of the relevant stakeholders. On one hand, the return on investment into repurposing of drugs, so that companies have indeed some incentives to do it apart from, as I mentioned, the patent system. And on the other hand is to address the access to modern medicines and high prices, which are affecting the governments and health insurance all over the world. And they're affecting us as taxpayers and potentially patients as well. And this need for the review was recognized, the need for some regulatory exclusivities for repurposed drugs. And for example, here there is a proposal which was made by Medicines for Europe for 4 years of data exclusivity as a separate reward for repurposing of drugs and for this value-added medicines. And it's in comparison what's actually in the US, where they have a 3-year system for new clinical investigation exclusivity, for example, for new indications when they are supported by proper clinical data. And such incentives would provide more balanced approach to return on investments and could make a balance between the interests of the relevant stakeholders and not to force companies to rely solely on patent protection. Now, addressing this issue of second medical use patents, there are several problems we can face with second medical use patents. I'll try to mention here some of them without going into the detail, but just to show you an overview. Clarissa has already addressed the problems with plausibility connected with inventive step and perhaps sufficiency. And the issue here is that when you file your patent application, you need to have some data to support this newly claimed use. On the other hand, you do not want to have much already included in the public domain, and especially in case of medical use claims, you have the clinical trial protocols, you have letters to patients, and this all prior art can have the effect that your new use would be obvious. There is also a great uncertainty on one hand in enforcing such patents. On the other hand, for generic companies, there is a problem and issue with marketing the products for prior art use, which is not protected anymore. And it is not always clear how generic manufacturers are able to sell the products for the use that was already that has already expired without infringing the patents for which specific use is claimed. And the problem is that you may not have the two distinct indications which can be perhaps carved out, but you can have overlapping groups of patients, you can have sub-indications. This refers to the in-label use where you have a broader indication and a patent is only for a specific type of indication. And you can have very serious problems with that. And also participation in the tenders, where the tenders should be limited to what is non-patented, but sometimes they are not, and also prescription practice in the given country. And this results often into costly and lengthy litigations. And was pointed out in one of the decisions noted here, a generic manufacturer cannot control the activities of doctors and pharmacists and users with which it is in no contractual relationship with. So there is a clear need for clarity on the generic manufacturers and providers of generic drugs on how to achieve this. With reference to one of the UK cases, health insurers in Europe are logically keen on having generic products within their portfolio. And reference here to the pregabalin case in the UK, which considered an infringement of a second medical use patent for one of the indications. The court ordered the NHS to prescribe only the innovator product for one of the indication and allowed the generics only for the other ones, but there was a cross-undertaking of the originator in damages, and the second medical use patent was finally revoked. And now there are 35 claimants, including the NHS in England, that are seeking compensation for this wrongfully granted order not to sell the product for the for both of the uses which were in the label. So this can have very serious consequences. Going back again to the pirfenidone example, just to show you the bigger picture and the whole IP landscape for a product, you can see here that a product which was authorized in 2011 did enjoy the protection by a second medical use patent for this specific disorder for which it was marketed, including the orphan market exclusivity, which ended in 2021. But then here noted in red, you can see all the secondary patents that are for various types of sub-inventions. And there were numerous litigations in this case. UK designations were withdrawn, and this is what creates and what results into numerous costly litigations and artificially prolongs the patent term extension. Even beyond here, you can see it's more than 10 or 20 years. And to conclude my presentation, I think there is a clear need for some balance between protecting the contributory inventions and preventing misuse of IP protection, because as I explained, it affects all of us. We are all taxpayers with health insurance, which have to reimburse costly innovator products, even though generic products could have been possibly available. How do we address this issue? It's an open question. One thing I wanted to point out here, we've heard from Nicholas about France and SEPs, and perhaps also for medical use claims or medical use patents, an injunction being an interim order or with a final decision may not always be the best and deserved remedy. We could take some inspiration from the SEP and FRAND licensing and perhaps come up with some way how to create reasonable royalties for these contributory inventions so that the products and the generic products are available for all the uses, and while at the same time, for you reward the innovator industry for these contributory inventions, and there may be other rules other ways how to achieve that. But I'll leave that as an open question, and thank you for the attention for now.
Thank you so much, Juri. That was really interesting, and Clarissa as well. And there are already some questions appearing in the chat, so if anyone else has any questions, feel free to add them in. The first one is for you, Juri. Do you know how much know-how the big pharmaceutical companies are keeping as trade secrets versus filing for patents? I think we're looking for a percentage here, which might be a bit of a challenge. This question comes because in the backdrop of COVID and the dispute around the IP waiver, some have argued that it would not be very useful to have free availability of vaccine-related patents because a lot of the know-how for producing vaccines or medications are protected as trade secrets.
This is a very, very good point. On one hand, I think we need to differentiate here between vaccines and generally, tablets and the general medications we have, because for that, I don't think there is enough much know-how that could be protected, which the generic companies would not be able to reveal by backward engineering and all this kind of stuff. So vaccines in this case are a very specific matter, especially the mRNA vaccines with specific technologies. Normally the medical products, capsules, tablets, and then the morely available technologies, they do not come with such a big know-how, so that anyone else would not be able to make it.
Yeah, that's a really good point, Jury, in the sense that some compounds are easier to reverse engineer than others and to scale up their own process, and the mRNA vaccines are challenging. I had a question about skinny labeling and how effective that is in Europe. We see it a lot in Australia and it has had some success, but I would say it's quite limited. How often do you see that, Jury, and is it working in this instance?
Again, it's, I think, a question country by country. We recently saw a lot of diverging decisions between countries on how courts assess skin labeling and perhaps contributory infringement. But then again, the problem, I tried to mention that during the presentation, sometimes it's quite clear that you can carve out an indication, right? You have clear indication A, clear indication B, you carve out one, you try to sell the product only for one, disregarding any problems you could have with tenders and all these kind of things. But on the other hand, you can have parts of indications which are very hard and almost impossible to carve out. For example, this in-label use, when you have a broader indication which was marketed, and then you have a patent on some specific group of sub-patients or some specific type of the disease, which is not really differentiated in the same way as in the patent in the SMPC. And this is almost not possible to carve out. And this is why should then the generics be prohibited from marketing the product for the prior use, which was already available, although it is not really distinguished in the label. And this is a real challenge how to address this, because I think that the public should have the option to access these generic medicines and not to be prohibited as a whole because some specific subgroup of patients is protected. And it comes back to regulatory challenges as well, because the regulatory authorities then have to enable you what can you carve out and what can you not. And it's not always easy.
No, I agree. It's a challenge in Australia as well. So I think it's something we'll continue to battle with. I think we're at time already. So Clarissa, sorry, I had a question for you, but I think I'll hand it back to the team and I can follow up with you separately. But thank you both very much for your time. That's been a really informative session. I really enjoyed it.
Thank you.
Thank you very much.
Very well. Very well. Am I audible to everyone? Hi. Am I audible? A thumbs up?
There's some feedback, Nevin. Slight
feedback.
Is
there? Sorry. Okay. Is it better now? But just to avoid the time lag, I'll just introduce. My name is Nevin Jacob from Dubai, currently specializing in patent law in the Middle East African region. I'm a member of the AIPPI Young Members Advisory Committee and the board member of the AIPPI UAE chapter. My role today in this event is to introduce the next session. I'm very well pleased to see more than 70 young members in this virtual event. The fact that you're still here, sorry.
Nevin, can you hear us? there is still background echo. Maybe is it because your mobile is somewhere around you and it's also you are connected?
Just switch off my mobile. Probably that's the reason. Am I audible better now? No. Am I still having that interference? No. Okay.
Maybe you can just leave and come back again. I don't know if it will make any change, but.
Or Debbie, would you be able to just to, for the interest of time?
It's okay right now. It's okay. Yeah.
So I think
go for it.
Debbie did the magic. Okay, so I'll just repeat myself. My name is Nevin Jacob. I'm specializing in patent law in the Middle East and the African region. I'm a member of the AIPPI Young Members Advisory Committee and a board member of the AIPPI UAE chapter. My role today is very small in this event, is to introduce the next session to all the participants. I'm very well pleased to see more than 60 young members in this virtual event. The fact that you're still there, even after 3 hours from the event start, speaks in itself. The exciting topics we covered by the well-versed speakers. I personally enjoyed each of the 4 topics we covered in the last couple of hours. Now to the final segment before the close of this exciting virtual event is the AIPPI IP Cafe, as you can see from the initial program. For those of you who have not experienced this, it's like a closed room where people sit around a table with coffee and tea, obviously in the real world. But for now, you can take your own drinks to the session. And then the host and the speakers will introduce the topics and share some content. Thereafter, the session will move to an open discussion with the participants in the room. Now to introduce, now what I need the participant to do is to pick a topic for the cafe, and when the breakout rooms are opened, please select one of the cafes to join. The 3 topics are influencer marketing and regulations in Europe. This cafe will explore influencer marketing, which is still relatively new, but is fast becoming a very valuable multi-billion-dollar space. The discussion will circulate around influencer marketing, regulations in Europe, how it has developed and where it may be going, with some examples of cases and decisions in this area. The second topic is NFTs and IP. This cafe will explore the world of NFTs and its relationship with various forms of IP. While it's been seen an endless possibility in terms of business opportunity, there are also a large amount of new legal and IT concerns. The third topic would be CreAItivity, insights into the realm of AI, artificial intelligence. The cafe will explore AI from different perspectives, from tackling AI issues of copyright and heading across to broader horizons of how AI aspects might be addressed in the consideration of free trade agreements. Just to repeat the 3 topics, the first one, influencer marketing and regulations in Europe. Second, NFTs and IP. And the third topic, CreAItivity, insights into the realm of AI. Before you all move ahead in selecting the topic, I've received a message from the events team requesting all participants to on their camera for a virtual group picture now. This will be used for an online marketing for this event. So I would encourage all participants to on their camera while the team would take a quick picture. Debbie, would you be doing it, or once it's done, just let me know?
Yeah, our events team will be taking the picture. So if they could let us know or have a countdown so they can take our picture.
Smile.
Okay, we are done. Thank you very much.
Perfect. Now, I would encourage the events team to open the breakout rooms. Just before you move out, make sure that once the session is over, please come back to the main session for the final closing remarks.
Hello, welcome back to the main room. I'm just checking if we have got everyone back. Not quite. I can see there are still some people in other breakout rooms. Or am I wrong? Has everybody come back?
They're coming.
Okay.
It's close to 52 now.
Welcome back, everyone, and thank you so much for joining all the wonderful sessions, and special thanks to all of our speakers, our young members joining and really sharing a lot of insightful topics. Thank you also very much for our committee members today for hosting our various sessions, and thank you so much for the events team for organizing everything. And also thank you so much, Annie and the Bureau for the support of today's session and summit. So thank you so much, everyone. And I'll want to hand over to Annie for our closing remarks for today. Thank you so much.
Right, I think Samantha has said all the thank yous I would like to do. And once again, a big applause to all of you who have stayed till the end of this inaugural AIPPI Young Members Summit. So I look forward to seeing you all in San Francisco, and we'd love to hear from you, what you think about this summit and how we may improve for the next time. So what sort of format you prefer? Of course, we surely want to have an in-person Young AIPPI Members Summit, but then so let us know what you think and how we can produce a even better summit for the next time. Big thank you to the Young Members Committee, and we owe you a lot, and hope everyone will have a good day, and hope to see you in San Francisco. Bye.
Yes, thank you, everyone, and see you in San Francisco. And we also have a feedback form that we will send out. And so hopefully you guys can all give us some feedback for our next session. And last but not least, we also have a WhatsApp chat group. So do join us in the WhatsApp chat group. I will send out the link again. And so we'll continue connecting with each other in WhatsApp, and see you guys again, hopefully physically. Thank you so much.
Thank you. Bye-bye.
Bye-bye.
Thanks, everyone.
Thank you.
Thank you. Bye-bye.
Bye.
Bye-bye.
Bye-bye.
Thank you. Bye.
Bye.